People against Hudson. Donald Earl Hudson, 25W838585A and B. You could come up to the podium, sir, and state your name, please. Name?
Donald Earl Hudson, Your Honor.
You're charged with improper plate and leaving the scene of a property damage accident. You have the right to a lawyer. If you would like one, I will appoint you one now at public expense. Would you like a lawyer?
Yeah.
Okay. We'll set you up with an attorney. You'll go talk to the lawyer, and then you will come back in front of me with the lawyer, okay?
Yes.
So you can go right out in the hallway, and he'll set you up. Good luck.
Come back another day or?
No, today.
Oh, okay.
He's an attorney?
Yeah.
Where is it? What's your name?
Nicholas Holmes.
What time is it?
9 o'clock.
Can I get your name, sir?
Yes, my name is Kenyatta Davis. I think that this case was put into one.
No, you're on the docket. Let me just get your attorney, okay?
Yeah, but I'm saying, like, I think this case, I know I'm probably on the docket, but I think this case was pulled because I'm currently in treatment. I was sent to treatment by another judge in this same.
Yeah, we know. That's how you got here. We sent the paperwork. Just hang on for your attorney, okay?
Okay.
Give me some tape.
Say that?
Give me some tape.
He's outside the hallway.
Yeah.
Do you want to use the carpet tape? We did really well with this one.
That's that.
That carpet tape that's on the back of it.
Let me just do this for stop there.
See.
There we go. I'll take more, and if you want to redo it, we can get a minute. It just drives me crazy when I get these things flat.
Yeah.
You're off the record, right?
No.
Can you grab all those files for me to sign that are on the end of my desk and review pretrial orders?
That is the Parkinson's. They can't speak English, but he understands everything. So when I talked to him this morning, he understood everything I was saying, but his interpreter is here.
Right.
So I can Crawford. So Crawford's got it.
Okay.
Okay.
Candace Williams,
Williams, I just look here.
840.
Yep.
Oh, my Lord.
We've been laid off for 4 weeks. I'm just,
How much do you get when you're laid off?
Unemployment, 4.
Ma'am, you've had this outstanding since April. You're making it what, $32, $33 an hour? Correct or false?
I'm sorry.
Is that true or false?
It's true.
All right.
I'm going through a divorce.
All right, okay.
I apologize.
Tell me, you can't pay anything today.
No, can
Tell me when you can pay this.
I can start paying next week.
How much, you get paid weekly, right?
Yes.
How much can you pay weekly?
At least $50.
All right. Sir, can you keep your voice down, please? Sir, can you keep your voice down, please? Thank you. You pay 50 per week beginning September. I'll make it the 15th. You can pay on Mondays, okay?
Okay.
If you need more time, you come and talk to me, either in person like this on or before the due date, or you call the court and we'll go on Zoom on or before the due date. I'll give you an extension. If you don't do that, you get picked up on a warrant. I'm not going to be very nice.
Sure it's paid.
You understand?
Yes.
Okay, good enough. Good luck. Thank you.
All right, thank you.
Good morning. How are you?
We are well. How was the court today?
Not too bad, thanks. All right. Lisa, I'm going to have John bring these set-asides down to you. People versus Derelict. Hannah Lee Derelict. 24B1465738. Your name? You work?
What was it?
Do you work?
Yeah.
Where do you work? Are you married?
No.
Is the father in the child's life?
No.
You've had this outstanding now for over a year.
So I went to court and paid all my tickets in like February and somehow, I seen you, but somehow this one got like missed.
Do you have this to pay?
Yeah.
Okay. I'll tell you what, I'll cut it down. You owe $248. You collecting child support?
No.
Why not?
His dad's SSI and can't get.
It's gotta be tough. Do you have just one child or more? And you're supporting 3 children? Is it the same father? How old are you?
Wait a minute. About to be 26.
Is he in the and he's not in the child's life? None of them? Well, that's great. These guys bring children into the world and they don't care about them, huh? Amazing. I'm gonna cut it down to 180 for you. I'll waive the balance. You go down and pay 180 and we're all set. Good luck.
Thank you.
I feel for you. Hang in there one day at a time, okay?
Thank you.
Good luck there, young man. How old are you? What's your name? What's your name? What is it?
Charles.
Charles. How's it going, Charles? Charles, how old are you? 3. Cool. All right, be good for your mom, okay? What is this world gonna be like when that child's my age, Lisa? That's what I wanna know. You know what, when they do these typical, when they come to these plea by mails, just go ahead and check on the in and out date. You know, when they send me these plea by mails, just check on the in and out dates before you even get them to me, okay? People against Nicholas Robert Holmes, 2-car W835 326. Your name, sir?
Nicholas Robert Holmes.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth self you've got.
Yes, sir.
Okay, so this is out of Woodhaven. You went and talked to Mr. Urich. I took this under 771.1 for 9 months. I sent you back on December 11 of 24. Since that date, have you been arrested?
No, sir.
Have you had any new charges?
No, Your Honor.
Any contact with the police?
No, Your Honor.
You did everything you're supposed to do?
Yes, Your Honor.
All right, good enough. I'm going to go ahead and dismiss the case. Motion of the prosecutor. Lisa, we need to take out all bond conditions on this one, or probation term conditions. You're all set. Wish you well. Best of luck.
Thank you, sir.
People against Frank Young. Gabriel J. Frank Young, 25W839 444. Could I have Ramel Howard and Shayla Gomez seated at the table up here, my right, your left? Sir, come on up to the podium. Your name?
Gabriel J. Frank Young.
You're charged with improper plate. You have the right to a lawyer if you want one. Do you want one?
Kinda.
Okay. We'll
I mean, I honestly don't know what I'm doing. It's the first time I've ever been.
All right, good. That's a great thing. Have a seat out in the hallway. He'll set you up with the lawyer, okay?
All right.
Come on up to the podium, Ramel Lavertis Howard Jr., 25W8385526.
Good morning.
Good morning to you. Your name?
Ramel Howard.
You're charged with resist, hinder, and obstruct an officer. You have the right to a lawyer. Would you like one?
Yes.
I'll set you up with a lawyer. So you can go out in the hallway. They'll set you up. Either way, you're coming back in front of me with your lawyer. Thank you. Shayla Nicole Gomez, 25W8389, 237A and B. Your name? Good morning. You're charged with driving on a suspended and no plate on vehicle, which is a civil infraction. Suspended is a misdemeanor, obviously. You have the right to a lawyer. Do you want one?
I'd like to, if we can handle this, quickly. I've paid all the fines and everything necessary.
So do you waive your right to a lawyer?
Yes.
I'll arraign you and I'll send you to the prosecutor, okay?
Okay.
On July 26 of 25, it is alleged that you did operate a motor vehicle on Allen near King and Woodhaven at 2:20 in the morning with a suspended license. That is a misdemeanor, punishable by up to 5.
Court. Any reason not to go into the matter of the sentence today? No, Your Honor. We have 0 days of jail time credit, no restitution, right?
That's correct, Judge.
Mr. View, anything from the state?
Nothing additional, Your Honor. Thank
Mr.
you.
Moss?
No, Your Honor.
Mr. Lyons, is there anything that you would like to tell me?
Just as far as my co-defendant, Nella Patterson, she really wasn't no willing participant in this. And I hope whenever it's her time, y'all have mercy on her. But other than that, I take full accountability for my actions. I'm guilty.
All right, court is going to impose a 9-month prison sentence. I'm going to order that this be served consecutively to the time that you're already doing, because a consecutive sentence is necessary to properly punish you, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. I do find that you're indigent for the purposes of fines and costs, so there will be no financial sanction. This does include an optional period of post-release control. That means the adult parole authority can, but is not required to supervise you for up to 2 years after your release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for that new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript or to pay the cost, they'll all be provided to you at no charge. Good luck to you. Of the State of Ohio versus Lisa Phillips, case numbers 25 CR 42777 and 25 CR 42725. Present before the court is Ms. Phillips. You're Ms. Phillips, right?
Yes, sir.
Represented by Ms. Hinkle, and we have Mr. Harris from the prosecutor's office. We are here today for a pretrial, but it's my understanding Ms. Phillips is going to enter a plea of guilty to some F5 charges in each of these cases, and we're going to set the matter for sentencing. Is that accurately stated?
Yes, Your Honor.
Yes,
Ms.
sir.
Ms. Phillips, how old are you?
I am 35.
How far did you go in school?
I graduated.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
Yes, sir. And treatment.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case. If you enter a plea of guilty to these charges, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. I'm going to set this for sentencing. That's going to take place in about 8 weeks. The plan is to put you into my community control program, which is what most people think of as probation. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have 2 sets of documents. They are each titled change of plea and entry, and they each have a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review these with Ms. Hinkle before you signed them?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to be entering a plea of guilty in the 777 case to 1 count of receiving stolen property and 1 count of aggravated possession of drugs. These each being 5th-degree felonies punishable by up to 12 months in prison and a $2,500 fine. In the 725 case, you're going to be entering a plea of guilty to 1 count of aggravated possession of drugs as a 5th-degree felony also. And these also carry with them, if you violate the terms of probation and I sentence you to prison, they also carry with it an optional period of post-release control of up to 2 years. Before we go any further, Ms. Phillips, I want to make sure that you understand your rights. You're presumed to be innocent in these cases, which means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris?
Your Honor, if these matters had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, this is to count 1 on the 725 case, that on or about May 26 of 2025, Lisa Phillips was found in possession of 1.85 grams methamphetamine. This was on a traffic stop in the city of Franklin, Warren County, Ohio. On the other matter ending in 777, this was on or about June 9th, 2025, city of Franklin, Warren County, Ohio. Defendant Lisa Marie Phillips was found to have 0.07 grams methamphetamine in her vehicle, as well as being, in possession of multiple ID cards, debit cards, bank cards, belonging to a Michael Kimbrell that was reported stolen back in December of 2024.
Ms. Hinkle, anything on those facts?
No, Your Honor.
Ms. Phillips, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think you've made a knowing, voluntary, and intelligent choice here today, only after you've been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. We're going to do a level 2 pre-sentence investigation, and we'll see everybody back here in about 6 to 8 weeks. What's their status of our treatment plan over at Genesis?
I'm there for 60 to 70 days. I'm now 94 days clean, and I will be doing sober living after I finish the program.
Okay, so is the plan to transition into, I mean, I don't want to get the cart before the horse here, but is the plan to transition into a sober living facility here locally?
It will be.
Or are you,
I'm sorry.
or are you going back to Akron?
No, I'm going to stay in Dayton. I'm going to go to Dayton. There's a good sober living called Full Circle. It's in Genesis registry. So that's what I will be doing when I graduate Genesis.
Okay, I'll see you back here for sentencing, a couple of months. Make sure you go back down to pretrial today, fill out the paperwork for the PSI. And Ms. Hinkle, you're going to go see Ms. Idle about the bowling case, right?
Correct, Your Honor.
All right, that's all.
Thank you, sir.
Thank you.
What happened to Mr. Clark? Ginger said she ain't seen him.
$93 days jail costs for all of those in 2 points. Do you understand that?
So I actually had paid everything.
This is a driving on a suspended.
Yeah, and it was supposed to not.
Okay, well, you can explain that to the prosecutor. I don't know. I didn't write the ticket.
Perhaps I do need the lawyer, then my apologies. I thought it was kind of something simple. Basically I had.
Okay, no, go out and talk to the lawyer
Thank you.
and then you'll come back in front of me, okay? So they all need lawyers.
Yep.
Thank you. People against Boynton, Robin Lewis Boynton II. 25W839319B. You're charged with driving on a suspended. Your name?
Robin Lewis Boynton II.
You have the right to a lawyer if you want one. Would you like one?
I think I need. No.
Okay, I'll go ahead and arraign you then, all right? On July 25 of 25, it is alleged that you did operate a motor vehicle in the city of Woodhaven on Western Ford Lane at 2:27 p.m. with a suspended license, a misdemeanor punishable by up to 500 fines. These are just the maximums. 93 days jail costs for all those 2 points. Do you understand that?
Yes, I do.
And did you sign, read, and understand the advice of rights?
Yes, I did.
If you plead guilty, you'll be giving up all those rights and we won't have a trial. Do you understand that?
Excuse me, can you repeat that?
Sure. If you plead guilty at any time today or in the future, you're giving up all the rights on that advice of rights and we won't have a trial. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to take this one to the prosecutor. You go out in the hallway. They'll come and get you as soon as they're available. Okay?
Okay.
Thank you.
Thank you.
Do you have anything else? Officer, what case are you here on?
I'm here for Jamie Atkinson. It was a traffic accident citation.
What time's that up? 9?
Yeah.
What's your name, sir?
I am an interpreter, Your Honor.
Oh, yeah.
Gonzalez.
Okay.
He's talking to the attorney. He says he doesn't need me. He doesn't know why they told me that he only gets the one for the first appearance. I don't know if you want me to stay.
I want you to stay. I want you to bring that defendant in with his lawyer. Tell him the judge would like to talk to him.
Yeah, they are talking in the.
I'd like him to come in here and talk to me. Okay, can you tell him to come in here? Or do you want me to tell my courthouse officer, do this for me? Stay right there. Go tell the lawyer and the defendant, what's his last name?
Delante Gonzalez.
Stalante Gonzalez. Bring them in here. And his lawyer. And the file. Lisa?
Yes,
Not a happy camper, right?
I know.
Just so you know,
I know.
he's in there talking to Plaza about.
The victim's here also, just so you know.
I want all the interpreter fees added up on that case. Do you understand me, Lisa?
Yes,
Good.
I'll check.
Thank you. Put them in the file, please. And I will have a little conversation with this gentleman. Good. I'm gonna wait about 30 seconds.
Yes.
Can you come up here, Mr. Interpreter? Mr. Crawford, come on up with that file.
Yes.
Want the victim in now?
I want the victim, I want everybody. Give me that. David Istolart Gonzalez, 25W86565.
Good morning, Your Honor. Michael Paul, representative of the defendant, stands to my right.
Name,
David Islar Gonzalez.
your name.
Mauricio Fernandez, the court lawyer.
And you are a certified interpreter in Spanish, correct?
I am, Your Honor.
Okay. Mr. And your name, Mr. Lucas.
My name is Carl Lucas.
What did you tell me when you came in the courtroom and I asked who you were?
Was an interpreter for this case, Your Honor. Mr. Gonzalez told me that he doesn't really need me. But he, I call him interpreter tonight, but yeah, the request was for the first appearance.
Did you tell him that? Yes?
Yes.
You told me you needed an interpreter.
Yes, I can answer from all of you.
The whole courthouse has been telling me that you were capable of carrying on conversation with them. I don't know why you're smiling. No. When it's your turn to talk, I'll tell you. The entire courthouse has been telling me for weeks that you're able to converse in English. You told me you needed an interpreter. If you want to play a game, I'll somehow figure out a way to give you permission to put a badminton court out back here, and you play out there. Go ahead. You don't bring interpreters in here because you want to be a wise guy. You don't come into a courthouse and act like you need an interpreter when you don't need an interpreter. Got it? You got it? How disrespectful. How incredibly misleading and disrespectful, Mr. Istolart. You know the good news about this? This upsets me. I'm not going to treat you worse. But you will pay for every nickel that the court's incurred and interpreted. Do you understand that? You want to play another game? Figure out how much his fee is going to be today. I'm going to release the interpreter, Lisa, please. I want that included as well. You guys take your time. Go back and see, go over the report. Maybe there's some kind of an explanation that he's been taking English classes since the time he was arraigned back in July, and suddenly, he's capable of speaking English. Maybe there's some kind of an explanation for all of this. I sure hope so. You've been a smug guy with me from the beginnings, Dallas. You want to be smug? You can be smug. This is not the place to be smug. This is serious business. This is very serious business. Go out. You still look like you're smiling to me, and I just can't even imagine. I cannot even imagine somebody looking smugly at the judge with a smile on their face after the judge just discovered, after bringing in interpreter after interpreter, that suddenly you wise up and you admit that you can speak English. I watched him say, "Follow me," and you didn't even hesitate. My court officer here, half an hour ago, 20 minutes ago, were you in the courtroom? He said that, and it was abundantly clear, but it's been kind of clear before. But see, I find it so outrageous and outlandish that somebody would look a judge in the eye and tell them they need an interpreter if they don't need an interpreter. I'm going to give you the benefit of the doubt. I hope you enjoyed yourself. I hope you got a lot of money too, because these interpreter fees, they're not charging $22.12 an hour. We'll talk to him, Mr. Crawford. Sir, you're released. Thank you very much. My sincere apology that somebody forced us to contact you and bring you in here when you had nothing to be here for. Go take your time. Here, give him this, please. I need to get off of this bench right now. Keep smiling, Mr. Istelar. Keep smiling. I hope you're enjoying yourself.
Mr. Lucas, I'm just going to put you back in the waiting room until they recall that case, okay?
Thank you.
For here, if there's serious property damage accident or anybody is injured in any way, I can't take impeding. So you tell me what you're offering.
We had not come to an agreement. I told her I would defer to the court. She was actually looking for, we didn't have a moment to speak. She was looking for the dismissal.
Okay, so you want to go to the hearing, ma'am?
Yes.
Okay, raise your right hands. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will reveal the whole truth, so help you God, officer. You swear to tell the truth?
I did.
You swear to tell the truth?
Yes.
Go ahead. No, you go first. You got to tell me what happened here, July 23rd.
Approximately 17:15 p.m. there was an accident involved between two vehicles at Dix Toledo, just north of Carter Road. One car being occupied by Ms. Atkinson and her fellow passengers. It was originally pulled off on the side of southbound Dix Toledo, north of Carter, so she can utilize the phone bus.
She's pulled over on the shoulder?
Yes, sir.
Okay.
Then when she went, she was done using her phone. She went to merge back into traffic, and another vehicle collided with her vehicle as she merged back into.
So the other vehicle was going southbound.
Correct.
Did the impact occur in the right lane?
Yes, sir.
And what did she tell you when you talked to her following the accident?
Ms. Atkinson?
Yes.
Ms. Atkinson said that she had pulled over to use this device, and then the other vehicle came out of nowhere as she's merging back into traffic.
What did the driver of the other vehicle tell you?
That the other female driver advised that she was southbound on Dix Toledo North Carter. And she did see this vehicle pulled over because Atkinson vehicle pulled on the side of the road. It was continuing at posted speeds when Miss Atkinson's vehicle just merged right in front of hers, causing the police.
Okay. Do you have any questions of him, ma'am? Of the officer?
No, I just,
Go ahead. Tell me your story.
I had just had a pacemaker implanted in my system and it was acting funny. So I had to pull over to use the phone device that runs the system. I pulled over to make sure that I was safe. It was actually an embankment. It wasn't off the shoulder. It was in a driveway, there was a fenced in area and it was a big enclosure. So I had plenty of room to pull off. I got done using my device and I went to come back out. I looked for my traffic. There was nothing there. I proceeded to pull out and I got hit in the passenger driver's tire. Even if
Wait a minute. Passenger, the left side of the vehicle, the driver's side of the vehicle.
driver's side, rear tire.
Okay.
If that vehicle was there, I would not have turned out.
Well, where'd it come from?
She just came out of nowhere. Like she had some either just pulled out of a driveway that was nearby and she kind of where she was going faster than what she should have been. Either way, she just came out of nowhere.
Okay, she has the right of way. We have no evidence that she was speeding. She has the right of way.
They have all the cameras and all the things inside the black box. That was a brand new EV. It Mustang. I have pictures of the accident. I have pictures of.
I'll be happy to look at whatever you have.
I have pictures.
I'll be happy to look at whatever. Let me see them. You can just pull the pictures up and he'll bring the phone up to me.
They start figuring. And then you got the. I'm not sure which way to like.
Yeah, but it is on Dix. The speed limit there is 50, right?
It's
45.
It changes as you go through. I believe it's sitting around.
Yeah, but I don't know what these pictures tell me, except that there's some.
I was turning out and if she was there, she would have had time to brake. She would have had time to apply brakes. I literally, I covered the lanes. She came back on, yeah.
Okay.
If you see the way that she hit me, it was dead on. It was, there's no way that she didn't see me pulling out.
Ma'am, she had the right of way. I'm sorry, listen. She has the right of way. I have no explanation for other than this, other than that she failed to yield the right of way. There's no way I'm an accident reconstructionist and I can tell by the damage to those vehicles that she was traveling in excess of the speed limit or anything else. I'm sorry, I'm gonna find you responsible as charged $195. You can go down the hall, you can pay that, and you can tell them you'd like to appeal that if you'd like, okay? You understand?
Can I at least get points?
I can't do anything on that. You said you wanted a hearing. I can't do anything with the points. I'm sorry.
As far as the money, is there any way that I can let that out there by going to jail or doing community service?
Do you work?
No, sir, I've been out of work since February. I'm dying. I don't have any money. I have nothing. I have more time than I do money, sir.
Do you have some note from a doctor?
My piece of paper right here, I have documents. I might have some in the car.
Do you have them here?
I have my pacemaker right here. I have.
Okay, you go get the documents, and then we'll talk, okay? You get the documents, you bring them up here, I'll look at them and I'll talk to you, okay? All right? Fair enough? Relax. I'm gonna be fair with you, just relax, okay? You're all set, officer, thank you. J1 Maurice Guy Neely, 25F243 946. 25F243 246B. 25F243 246A. 25F243 246C. Your name? I'm sorry?
J1,
You gotta tell me your whole name, sir.
J1, G, A.
You have all this to pay? You owe 195, you owe 213, you owe 321 and 213. So I can do the math. You're telling me you have somewhere near $1,000? I thought you just said you had the money to pay all these. I can't hear you. Voice up.
Said that I had to pay. I was trying to pay him, but
Where do you work?
I wasn't.
Why not?
Never got it.
Did you graduate?
I was like,
You're not on disability, are you?
no.
So you owe 195 and 213, which is 395. That is 408 plus 321 is 729 plus 213 is 942. So how much do you have today? Why aren't you working?
Never got it.
Did you apply?
Yeah.
Where do you live?
But
With who? Your older sister? You don't show up here. You haven't been here. I mean, these tickets are from January of 25. All of them are from January 7 of 25. You didn't show up for show causes. This one, I suppose, is from April 30 of 25. Your record's horrible. What am I supposed to do with you?
I was getting done paying for it. Because I couldn't pay it.
How are you going to pay this if you're not working? Tell me how you're going to pay it if you're not working.
I'll be doing helping my cousin, because she like
How much can you pay per week?
between 60 and 90.
I'll have you pay 40. When can you start?
By the end of this week.
All right. Lisa, I'm going to let you set up a payment plan on all these. You can print them out. I'm not going to write on these. You can set up 40 a week. I don't care which one's paid first, how you do it. And just set them up for 40 a week starting September 15th. I'll give you a little bit of leeway time. If you don't have the money, it's not a problem. You just come and talk to me on or before the due date. Or you call the court, we'll go on Zoom and I'll give you an extension.
Okay.
But you don't ignore me. I don't like that. Don't ignore courts. That's a bad habit. People get in those habits. I don't understand it. Do we understand one another? I'll give you 49 extensions if I need to. But don't ignore me. Okay? All right, good enough. Cody David Bryman. 25W839281. Come on up. Your name?
Cody.
Sir, you're going to go right down to my judicial clerk. We'll bring the files down. I'm sorry, say your name again.
Cody David.
You're charged with disturb the peace.
Yes.
You have the right to a lawyer if you want one. Would you like one?
And legal, sir.
Pardon? I didn't hear you.
Yes.
Okay, we'll send you to a lawyer. And then either way, you're coming back in front of me, okay?
FC Hall.
Good luck. Do I have anything else down there? Pardon?
I have nothing.
Tell Mr. Crawford I'm ready on this, please.
So take the prosecutor. There's only more submitted search warrants whenever you can get to them.
You have them come in here.
Okay, that's what I'm.
Do we have, I think I got to set it down. People against David Istolar Gonzalez, 25W836565.
Morning, Your Honor. Michael Crawford, representing the defendant. Sir, please state your name for the record.
Name,
They still are outside.
your client pled to attempt MDOP back on August the 6th. The prosecutor dismissed the malicious destruction of property charge. I ordered a pre-sentence report. Have you had the opportunity to review the report with them, and are there any material additions, corrections, or deletion?
I've had the opportunity to review the report with my client, Your Honor, and there are no material additions or deletions that we request at the time. I find that we can apply the recommendation, and we ask the court to adopt it.
Mr. Lucas, your name?
My name is Carl Lucas.
All right, so I'm going to listen to what they have to say. They're urging me to adopt the recommendation. I'm going to go on to Mr. Istolar Gonzalez, and then I'm going to ask you if you have anything to say, okay?
Yes,
Sir,
sir.
would you like to say anything?
You're speaking to me?
No, I'm asking Mr. Istolar Gonzalez.
Thank you, sir.
Is there anything you would like to say, Mr. Lucas?
I did submit a letter to the court demonstrating the damages that were done to my vehicle, and I paid to have those corrected. I just want reimbursement.
How much were the interpreter fees, Lisa? And I want you to estimate how much we're going to pay that gentleman today. I think it was $160 an hour. I don't know.
They charge $160 an hour with a 2-hour minimum and an $80 travel fee.
So that's $400 on my math.
Yeah, he's been here 3 times, so I figured it to be $1,200.
$15 probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, your home telephone number, you must notify probation. You have to report as directed. You're to attend the anger management program with follow-up. You're to obtain and maintain employment, provide proof. I see that you are working, making $2,000 a week. You're not to have any contact with the victim, Carl Lucas. You cannot write, phone, seek, text, email, or communicate with him in any way or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. You're to serve 4 days on the court work program. There's a $35 a day charge for that for a total of $104. You're to pay fines $100, costs $100, 75 victims' rights fee, $50 justice assessment. So fines and costs are $325. You have probation fees of $300, bring the total to $625. You have attorney fees in this case of $100, bringing the total Let me just do my math here again. $325, $625, $725. You have court work program fees of $140 for a total of $865. I want to make sure that I'm getting the fees right, Lisa. You're to pay restitution through the court to the victim, Mr. Lucas. You're to pay through the court in the amount of $1,265.50. That brings your total to $2,130.50. You're to pay interpreter fees of $1,200.
Robertson. There is a little bit more discovery that we would like to review together prior to making a decision on what to do with the case. We would like to address bond if the court would allow it.
Okay, go ahead.
Thank you, Your Honor. Mr. Robertson has a place to go if released. He could live with his brother at 741 Bishop Avenue in Cincinnati. Mr. Robertson indicates that if released pending further hearings, he will be compliant with all rules of pretrial supervision. He had just recently gotten a very good paying job the night of the alleged incident, and that's why they were actually out there celebrating and getting excited for his new job. He would like the ability to go back to work and sort of get stabilized and back on his feet, and he promises that he will follow the rules if released.
Mr. Few, state position in this?
Well, Your Honor, we're opposed to release. I mean, first, regarding Marcy's Law issue, I mean, we have 2 separate victims on this case, the officer victim on count 1, as well as the victim, Kathy McCready, who is the victim of counts 2 and 3. Both are entitled to notification of any bond modification. On the state's request is that Ms. Kirby file a written motion for bond modification and give us an opportunity to get input from the victims related to that. Additionally, just given the seriousness of the offenses in this case, the fact that there are 3-person felonies involved, we're opposed to release. The information we had was that he was homeless, was living at Bernie's house. So I think in terms of stability, certainly if he were to be released, he'd have to be on monitor. And I think community corrections would need to follow up to find out if that's an appropriate placement for him.
Ms. Kennard?
Your Honor, I don't know what the victim's position would be. I know the jail has had to block 6 different phone numbers from the defendant trying to call Ms. McCready already. But I don't know what their position would be without it.
I mean, she was here for the hearing and then she left, right?
No, I was mixed up on cases. It was the Tracy Ward's victim that
Oh,
was
okay.
here. Ms. McCready's not shown up today.
Okay. So here's what I'm going to do. Let's set this maybe next week. And I'm going to have community corrections go ahead and check out the residents. Ms. Kirby, you can go ahead and file a written motion and we'll come back here late next week and revisit this issue. And that way I will know more from my community corrections folks whether or not the brother in Cincinnati's address is a viable placement. We can also find out the position of the victims in the case.
Okay, fair enough, Your Honor. Thank you.
Okay, all right.
Or the trial date for October the 8th.
Oh, did we get a time? We're doing a time waiver?
I will.
Wait, hold on, Mr. Robertson.
Your Honor, the fact he has been in for 60 days at this point, he indicates. So we will file a time waiver next week or just get it set for trial if that's okay.
I mean, we're essentially 30 days out from trial now. So we're going to go ahead and set a trial date.
We can do that.
Might as well set it on the 25th.
9/25.
So, I mean, if you want to set it for trial today, we can. If we want to wait until next week, we can. But that's going to be your trial date.
Okay.
I just want to make sure we have sufficient time to subpoena witnesses.
Okay, we'll go ahead and set it for trial on the 25th then. And we'll see you next week. We can always vacate that later. All right, who's next? All right, this is the case of the state of Ohio versus Brandy Brown, 21 CR 38009. Present before the court is Ms. Brown. You guys can be seated, represented by Ms. Kirby, and we have Mr. Harrison, Prosecutor's Office. Officer Kell from probation. We're here today for a final violation hearing. Ms. Kirby, does your client wish to have a contested hearing in this matter?
Your Honor, I have advised Ms. Brown of her right to have a hearing. She has elected to waive the hearing and admit to the violation.
Do you understand the right you're giving up by admitting to this violation?
Yes, sir, but I would also like to be able to speak on my behalf for a moment also.
Okay. So what we do, Ms. Brown, is we break a probation violation into 2 parts. First of all, what did you do, if anything? And then the second part of that is, what are we going to do about it? When you admit to the probation violation, we skip over the first part, which is essentially that you admit that you were unsuccessfully discharged from recovery works and you absconded. Then you can talk about what we're going to do about it. This is the second part. If you dispute that you violated the terms of your probation, then we should deal with that up front. Does that make sense to you?
No, I fully admit that I was irresponsible and did the wrong thing.
Okay. All right. So based upon your admission, I find you have violated the terms of your supervision. Mr. Harris, anything from the state?
Your Honor, as we discussed in chambers, I believe that probation believes the CBCF would be beneficial for the defendant, as well as electronic monitor upon the release and completion of the CBCF. As we discussed, our program, it appeared, had accepted her.
Officer Kell?
Your Honor, that recommendation is correct.
Ms. Kirby?
Thank you, Your Honor. I have been in discussions with Ms. Brown. She indicates that she has been accepted to Recovery Works and Mindful Healing. She believes that going to one of those programs would be extremely beneficial for her.
And I would like an ankle monitor.
And I believe she would like to address the court as well.
Okay, what do you want to tell me?
Your Honor, you asked me before if I wanted to go back to Tennessee. I do. My daughter's there. And I don't think me getting put in a 6-month program or whatever is beneficial to me because I don't plan on staying in Ohio. I would like to go to a sober living with an ankle monitor and be able, because I'm gonna have to go to the doctor. I have issues that they weren't able to take care of. I've been on the doctor's list for the whole month that I've been in the jail in Warren County. I need to be on antibiotics for my teeth. I need to get the few teeth I have left removed before infection gets in my blood and kills me. I couldn't get treatment for my plaque psoriasis. So I mean, I'm gonna need to go to doctor's appointments and be able to set stuff up myself. I would love to be on ankle monitor. I mean, I'm not going anywhere. And as it was like 4 years ago, supposed to be, I would like to be transferred back to Tennessee, but at least be able to be working a program while that process is going on.
Okay, does the 95 days of jail time credit, does that sound right to everybody?
Yes, Your Honor.
Yes, Your Honor.
So, Ms. Brown, a couple of ways we can go in this case. You've been gone for a while, and
Yes, sir. I was afraid, honestly, because the way I saw it, you weren't very nice to me 4 years ago, and I was just scared to come back and be in front of you because I thought you were going to be mean to me, honestly.
Okay. Well, my note to myself back in 2021 was that you probably needed a community-based corrections facility, that I didn't have a lot of faith in the Recovery Works plan, that you had some dental needs, and you said you never had a chance at treatment. That's what happened back in 2021. We gave you a chance at the treatment at Recovery Works. Didn't work.
Well, mindful healing is more of a, like, you can't go anywhere, that you can't have your phone for the first 2 weeks. And then after 2 weeks, you still can't go anywhere. You can sign yourself out for 45 minutes at a time. You can't work for the first 45 to 60 days. It's all treatment. I don't have any clothes or anything here. They have like donation clothes and stuff. They would be able to help me get my food stamps and get all my stuff on track. Like I said, I talked to them yesterday, and she said that she already had it in the works, that they could come get me as soon as I get out of court and have my ankle monitor put on and get me clothes and get my food stamps set up and help me get back on medication and get and do my treatment and stuff.
We're not doing that, Ms. Brown. So your choices are, you can do an additional 180 days in the county jail. So that would mean 275 with credit for the 95. No, I think that might be right. I don't know, whatever that math ends up doing. You can do an additional 180 days in the local jail if you want. If you want to do the STAR program plus some sort of sober living after, or we can transition you to Tennessee after you're done with the STAR program. You can do that, or I can send you to prison today. It doesn't really matter which one of those we do. We're not trying the Recovery Works thing again. We tried it. You vanished. That's on you, not on us.
Well, no, mindful healing.
So this is not a conversation, Ms. Brown, about how we think that things might go, where you suggest things and I say things and then you consider what I say. It doesn't work that way.
Sir.
You have 3 choices in front of you. You need to pick one. If you want some time to talk to Ms. Kirby about that, you can do that. If you want some time to think that over while you're in the jail, I can set this next week and you can think that over, but you can go to the CBCF, you can serve out local time, or I can send you to prison.
I mean, what even is the STAR program? Nobody's told me, like, I haven't been able to talk to my probation officer or anything. I've left her messages. She hasn't contacted me and told me anything.
The STAR program is a 4 to 6 month treatment program. It's a little more of the progressive boot camp kind of thing where they give you more to do. You go to bed tired at the end of the day sort of program. It's more intensive than, say, a Monday or a CCC type of program. Good program. We have a lot of successful people that graduate and do well from that program. It is our preferred program right now.
So you can't even smoke there or anything either, right?
I have no idea.
It's like a lockdown facility, no.
I don't think you can smoke in any facility that is run by any government funds, but I don't know the answer to that.
I mean, if I were to go to prison, how much time would I get?
I would give you 9 months in prison.
9 months. Can I talk to?
Sure. Do you want to talk today, or do you want me to reset this next week?
I would like to talk today.
All right, take some time, talk to Ms. Kirby, and then we'll see where we're at. Are we ready, Ms. Shaw, on the Whitmire case?
We are, Your Honor.
Ohio versus Antoine Whitmire.
Why did he ask me?
This is case number 25 CR 42733. Present before the court is Mr. Whitmire, right?
Thank you.
You're Mr. Whitmire, right?
Yes, sir.
Represented by Ms. Shy. We have Mr. View from the prosecutor's office. No, Mr. Harris. Mr. Harris from the prosecutor's office. We're here today for a pretrial, but it's my understanding Mr. Whitmire is going to be entering a plea of guilty to 1, 2, 3, 4, 5, 6, 7, 8 F4s. And we're going to set this matter for sentencing. Is that accurately stated?
Yes, Your Honor.
Mr. Whitmire, how old are you?
31.
How far did you go in school?
Got my GED.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case. If you enter a plea of guilty to these charges, I'm going to conduct a pre-sentence investigation, and we're going to come back here in about 6 weeks for sentencing. I am going to screen you for a drug treatment program, someplace like the Coach, Full Circle, one of those types of places. And this seems like the kind of case where I would give you local time and then get you into a treatment facility. But we'll do a pre-sentence investigation and come back here for sentencing. Other than that, though, has anybody made any threats, promises, or representations to get you to plead guilty to these charges against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the 3rd page, there is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Ms. Shy before you signed it?
Yes, sir.
Are you satisfied with the representation that you have received in the case?
Yes, sir.
You're going to enter a plea of guilty to 4 counts, 5 counts of trafficking in cocaine. We have 3 counts of trafficking in a fentanyl-related compound. These are each 4th-degree felonies, punishable by up to 18 months in prison. There is no mandatory prison in the case, but if I put you on probation and you violate, and I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. But each of the 4th-degree felonies carry with them a punishment of up to 18 months and a $5,000 fine. Before we go any further, Mr. Whitmire, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished, that you either plead guilty or the state of Ohio proves that you're guilty. If it can, you have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, as to count 1, 3, 4, 6, 8, 11, 13, and 14, that on or about April 23rd through May 28th of 2025 in Warren County, Ohio, defendant Antoine Whitmire did sell drugs to undercover detectives with the Warren County Drug Task Force. On count 1, that was 6.24 grams cocaine. Count 3, 6.69 grams cocaine. Count 4 was 5.14 grams cocaine. Count 6 is 3.21 grams fentanyl. Count 8 was 5.41 grams cocaine. Count 11 was 3.46 grams fentanyl. Count 13 is 9.79 grams cocaine, and count 14 was 2.91 grams of fentanyl.
Anything on those facts, Ms. Shaw?
No, thank you, Your Honor.
Mr. Whitmire, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Good.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. How long have you been in jail so far, Mr. Whitmire? Do you know?
4 months. Since May 28th. 4 months.
Okay. I'm probably going to go ahead and send my case manager, Ms. Wilkerson, out to see you. So if you want to talk to her, she's the one that works the placements and refers to the sober living facilities. So talk to her about where we're headed in this case. We will do a PSI. And here's the thing, Mr. Whitmire. I know we haven't gotten to sentence yet, but the plan is to put you into my community control program. If I send you to a program either before sentencing or after sentencing, I do have a concern about sending drug traffickers into my treatment facilities because there is a concern that you will continue your business activities while you are in that program. I just want to make sure that you know up front if there's any whiff that is what is going on in the treatment facility. I will impose consecutive sentences on you for each of these charges. So if you are dealing drugs in any of my facilities, you're going to go to prison for every day that I can send you. I don't want to be that scoldy guy that points his finger and thinks the worst of you, because I don't know that it's going to happen. I just want to make sure that you understand the water is very deep for you if that happens. Okay? All right. We'll see you next time out.
Your Honor, just briefly, he has already been accepted into the Full Circle program.
Okay.
And he has spent 4 months in jail already. He has never been to treatment before and wants treatment. Is there any way that he could be released into the program pending the PSI?
Yeah, I mean, I'm going to send Ms. Wilkerson out to see him, and then what happens is she will talk to you. She will confirm with Full Circle that we have a bed date, then she will staff the case with me, and one of three things will happen. One is that we will send you to the facility on a monitor. One is we will send you to the facility without a monitor. The other is that we wait until sentencing to decide that issue. So talk to her, and then everything kind of runs through her.
Great. Thank you,
Okay?
Your Honor.
All right, that's all. All right, the next case is the State of Ohio versus Robert Ray, 22 CR 38873. Present before the court is Mr. Ray, correct?
Yes, sir.
And we have who's doing PVs today, Mr. View, and we have Officer Rose filling in from probation. We have received a report, Mr. Ray, that alleges you have violated the terms of your supervision in that you absconded from probation. You do have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
Well, I'm guilty.
Okay. Sometimes guilty people need lawyers more than anybody, Mr. Ray, but I will tell you the recommendation in this case is that I give you 90 days in jail and just be done with it. So there's a couple of ways we can go. If you just want to do that, then that's fine with me. If you want to represent yourself and set this for a final so that you can maybe present me with some other options about what I should do, I'm okay with that also. If you want to be represented by a lawyer to help you to present me with other options, I can do that as well.
I think that would probably be best to be represented.
Okay. I think I previously appointed Ms. Carr to represent you.
I believe it was. Yes.
Any reason I shouldn't appoint her again?
No.
All right. Ms. Carrillo has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. All right, I do find you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Ms. Carr to represent you. You have her contact information there. We're also going to send her an email today that lets her know that she's been appointed, and I'm going to set this for a final hearing in about a week to 10 days. Is there anything you want to tell me today?
No, just that I've been detained for 93 days, and I did do an inpatient IOP program. I've been in intensive care for the last 90 days.
Okay, where were you detained at?
Butler County.
Okay.
Where they detained.
Do you have charges pending in Butler County still?
Do, yes.
What kind of charges?
It's a drug possession charge.
Okay. All right, I'm going to appoint Ms. Carr to represent you. I do find there's probable cause to believe you have violated the terms of your community control. I'm going to hold you in jail. See you next week.
Okay, thank you. Yes.
We need more time, Ms. Kirby?
To you. You gotta make your decision.
Okay, go ahead.
At my preliminary, I mentioned I would like to go back to Recovery Works or sober living. And you kind of were like, well, I'll, put that on the table as an option if that's what you decide to do. And I mean, you asked me if I wanted to go back to Tennessee. Like I just don't understand why I have to be stuck at a program for 4 to 6 months here when my wife is in Tennessee. My daughter's in Tennessee. Like, my parents are old. They're not gonna be able to take care of her for very long. Like, I'm just trying to figure out like why I have to be stuck here trying to, make a place here whenever my life is going to be there. So whatever I do here for 4 to 6 months or whatever, when I go back there, I'm going to have to start over from scratch again. See what I'm saying?
I mean, my general thought process on this, Ms. Brown, is that you need to be incarcerated for a period of time. And that is the both punishment aspect of this, also protection of the public aspect of this case. I sort of prefer that you spend that time that you're away from society in some sort of treatment, either behavior modification, drug and alcohol treatment. That's why the STAR program is better than just serving out your time in jail or in prison.
I mean, I don't really have much of a choice on anything. So like, at least that's the way I feel.
We have 3 options.
I mean, I guess STAR, since I really don't feel like I have a choice in anything.
I mean, the reason that we make the treatment the most palatable of the decisions for you is that I think the treatment is what is best for you.
But I don't have anybody to do anything for me. I won't have any way to make money or be able to have any kind of anything, even soap, shampoo, anything. I don't have anybody to do anything for me. I won't be able to work. I won't be able to do it for myself. So I'm just going to have to be in a program for 4 to 6 months doing without everything. Like, it doesn't seem fair. That's all. Like,
All right, the court is going to continue you on community control. I'm going to modify the terms of your probation to order that you enter into and successfully complete the STAR program. Between now and the time that you graduate the program, we need to put a plan together to, if you're going to be going home to Tennessee, we need to do an ICOTS transfer to transfer your supervision down there.
so I can't even get it transferred before 4 to 6 months.
We don't transfer your supervision until you get out of the program. So as you're getting near the end of the program, one of our ICOTS officers is going to meet with you. We're going to try to get the transfer down to Tennessee. That seems to be the most sense. Otherwise, we need to transition you into some sort of acceptable housing. I am going to allow your officer to put you on EM for a period of up to 45 days if you are remaining here in Ohio. And I'm going to give you credit for the 95 days that you have already done. Good luck to you, Ms. Brown. Are we doing something on Mr.
Sally's
case?
Your Honor, do you care if I have just a second
No,
to talk
go
about?
ahead.
I'm sorry, I didn't get a chance to before.
Your total here amounts to $3,330.50. If you violate, your probation could be revoked. You could be incarcerated for 45 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. If you violate, you're going to get 45 days, or you can get 45 days. Do you understand?
Yes.
Do you have all of this to pay?
That would mean a payment plan.
I'm not going to be very patient with you. Okay? How much do you have today?
$100.
I'm sorry?
$100.
You make $2,000 and you're single every week and you don't have more than $100?
That's the relatives outside.
I hope you've enjoyed this little experience. I cannot believe you did this. I know you're sitting there smirking again.
San about to be.
Pardon me?
San about to be.
Go ahead and appeal. And I hope the record's abundantly clear. Because you've had fun in the system. You have no respect for the system. Go ahead and appeal. Like I'm afraid. Give me a break. Go ahead and laugh all you want. You're going to pay $100 a week. And if you need more time, you're going to have to come in here and talk to me. Okay? Let's all have a good laugh. Let's all have a good laugh with Mr. Installard Gonzalez, beginning September 15th. $100 a week. He thinks he's funny, huh? You better show up for everything, Mr. Gonzalez. You don't, you go to jail. That'll be funny, huh? Have a great day.
Your Honor, just to be clear, his first $100 payment is due today, correct?
Yes.
So they're gonna send check
Yeah, we'll accept the check
or credit card.
or credit card, whatever you want. You get points.
But young girl, look at it.
See what? What did he say, Mr. Crawford?
What you say, Mr. Esquire?
Come on back here.
Come on back here.
That's what I said.
Right?
You're not gonna see me in court.
Oh, no.
No, you get to go in front of another judge and play with them for a while. How's that? Enjoy your journey through the criminal justice system. Mr. Lucas?
Yes, sir.
I'm sorry that you had to listen to all of that. I'm just amazed that somebody, I don't know what's going on anymore, to be honest with you. But that was, I'm not surprised that his conduct elevated to the point that it did on the date of the offense. Let me just put it there. Have a great day, sir.
Yeah,
Good
thank
luck
you
to
for your
you.
time.
Thank you very much. People against William Brush. William Matthew Brush, 25W8388383. I don't, Ms. Aycock, your name? Ms. Aycock? It's going to appeal. Yes. Good morning, Ms. Aycock. Your name?
Good morning, Your Honor. Leslie Aycock, on behalf of the defendant, William Brush, who's present in my office to my right. Can you please state your name for the court this morning?
William Brush.
So I can give you 2 more weeks. Are we doing the 17th, Lisa?
The 17th at 8:45.
At 8:45, okay?
Would it be, I'm scheduled to be in person in front of Judge Hessen that morning at 10. Would it maybe be possible to come see you in person instead of by Zoom, maybe about like a little 9:15?
Oh, that's fine.
Okay, thank you, Your Honor.
9:15 will make it, okay?
Thank you very much.
All right, have a good day. Good luck, sir. Your bond is continued.
Thank you.
Take care.
I'll make a note in person here.
Thank you, Your Honor. Oh, can I see your papers? Good at papers. I just want you to get the papers first. Ma'am, just hand him the papers and I'll look at them, okay?
It is terrible and it goes back a long way. The gun is something new. I don't know in the whole, let's see, 12 years that you and I have been involved in each other, that your case has ever had a gun element to it. That's a new sort of thing. That gives me some concerns. I don't know what I'm going to do. So I think we can agree it's not possible for anybody to have made you a promise about what your sentence is going to be, right? Has anybody made any threats, representations, any promises to get you to plead guilty to this against your will?
Yes, sir.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Ms. Kirby before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of weapons under disability. It's a third-degree felony. It's punishable by up to 36 months in prison and a $10,000 fine. There is also a specification for the forfeiture of the weapon that was involved in the case. If I do send you to prison, the maximum penalty includes an optional period of post-release control of up to 2 years, but there is no mandatory prison sentence in the case. I could put you in probation, local jail. I really have no idea. Before we go any further, I want to make sure that you understand your rights. They really haven't changed that much since we went over them the last time. You still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, this charge and the specification, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count one and specification to count one, that on or about May 26 of 2025 in the city of Mason, Warren County, Ohio, defendant Christopher Sully illegally possessed a firearm having a prior felony conviction. This was in a motor vehicle after a traffic stop.
Anything on those facts, Ms. Kirby?
No, Your Honor.
Mr. Sally, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes.
Do you understand the right you're giving up by entering plea?
Yes, sir.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you've been fully advised of your constitutional rights, which you waived and rejected here in open court. We're going to do a level 2 pre-sentence investigation, go back down to pretrial, fill out the paperwork for the PSI. I'll see you in a couple of months.
Thank you,
All
Your
right.
Honor.
Thank you, Your Honor.
That was an aggressive morning in which we executed well.
In the meantime, any changes, any new?
Excuse me. I have two doctor's appointments today, one at 4 and one at 1 o'clock. My aunt just took all of my other paperwork to the house to help me file for SSI.
Okay, let me recall the case. Amy Heather Adkins, 25B148-304. Your name? Look, here's what I'm gonna do. I can't tell from any of this. I mean, I see you're going through something, but I just can't tell. I'm just gonna give you 2 months to pay. And you can take back all your paperwork. And if you want to bring me other documentation, I'll be happy to set up a court date for you, okay? So I'm going to give you until November. Lisa, can you schedule, I'm going to give you till November 3rd to pay. And if you have something that you want me to look at, I'll be happy to do that for you, okay? But I can't tell from that.
Well, just so you know, this is my husband, all I paperwork showing that I'm out of date. These are the check stubs that I
Okay, and I hate to be so morbid about it. Please listen, I have people lie to me all the time.
don't have anything to lie about, sir. I have enough.
No, I understand. I'm not saying you are, but I need some documentation, strangers.
This right here shows that I had the implant
Okay.
on that day. Like, this is my complaint card.
What do you want me to, ma'am, I can't just waive your fines. You said something that was very traumatic. I can't just waive your.
Oh, I'm asking. Can we do community service or jail time?
I'm not gonna send you to jail on a speeding ticket, man. Or a failure to yield ticket. I'm not gonna do that. If you want to do community service, but I would think if the medical condition has risen to the level it has, that you wouldn't want to do community service either, right?
I have no problem feeding people. I do it for community. But
I'll tell you what, you want to do community service, I'll let you do community service. Defendant may pay fines and costs of $195 by November 3, or perform 14 hours of community service by November 3. Okay? So either one that you choose to do is up to you.
so much. I just bring the proof back up here.
Correct. Okay? Best of luck to you. I wish you well. Good luck. Thank you. Ramel Libertus, Howard Jr., 25W8388526.
Good morning, Your Honor. Should I get my final votes?
Sir, your name? For purposes of arraignment, does he stand mute and waive formal reading?
Yes, Your Honor.
Not guilty, please enter. $500 postal bond. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. Do you understand that?
Yes.
Said he kicked an officer too. No contact with the victim or prosecution witnesses, okay? I'm not saying he did that, but that's the order of the court. No contact with the victim or prosecution witnesses. Okay. You're going to give you a new date, by the way, and you're going to have to fill out a petition for a court-appointed lawyer. Do you work? Why aren't you guys working? I don't understand why people aren't working anymore.
Working on something that we can companies, so it's like.
I got everybody coming in here, it seems like, not working. I don't want to overgeneralize by saying everybody, but I don't know how people eat. Some do. There must be some secret out there. We doing the 17th, Lisa?
Yes, 9 o'clock.
At 9 a.m., September 17th at 9 a.m. So you're going to have to fill out a petition for a court-appointed lawyer. Go down the hall, get your notice, and we'll see you back here that day. Any questions? All right, best of luck. Gabriel J. Frank Young, 25W839-444.
Well, good morning, Your Honor. Chris Bishop, you're getting my client instructions.
Sir, come on up here, state your name.
My name is Gabriel J. Frank Young.
Does he stand mute, waive formal reading?
Yes, Your Honor.
He's going to plead to the civil infraction, the expired plate, the improper plate will be dismissed, right?
That's it, Judge.
Who do you get that Fu Manchu going on there with?
Judge, I'm just trying something new.
It looks good. Looks good on you. It makes a good-looking guy look better.
That's what I show you.
You want to plead to civil infraction?
Yes, sir.
To that charge of expired plate, responsible or not responsible?
Responsible.
All right, I'm dismissing the misdemeanor, accepting your plea. 150 is the total. You can go down the hall and take care of that, and you're all set.
Awesome, thank you.
Best of luck. Gomez, Shayla Nicole Gomez, 25W839-237A and B.
Good morning, Your Honor. Chris Bishop, you're getting my client's 97th held in person as the arraignment wait for reading my client's case.
Ma'am, your name?
Shayla Nicole Gomez.
I'm entering a not guilty plea for purposes of arraignment. She's going to plead to impeding. They're going to dismiss the suspended. She's going to plead to expired plate as opposed to no plate, right?
It's my understanding that they're dismissing the driver license suspended and the no plate, and then she's just pleading to an impeding traffic. She has a valid plate and.
I see.
And she has a valid.
I see. Dismissed per step. Okay. My apologies. You're going to plead to a civil infraction of impeding, right?
Under my counsel's.
Is that what you want to do, though?
Quite frankly, no.
Well, then go,
Just wait for that recall.
hang on a second.
So I.
Wait, just wait. She came up here before and she told me she had a valid license on July 26th.
Judge, and it's being dismissed, so it's not really a point of my concern.
Right.
But the plate was not valid, and then the prosecution is dismissing the civil infraction and going.
I just purchased the.
Yeah, don't interrupt your lawyer. You don't have to do anything. You can go to trial on the driving on a suspended. Maybe they'll move to dismiss that then. And you can go to a formal hearing on the plate violation. So if you don't want to do this, what your lawyer worked out, you don't have to. It's up to you.
I have a great deal of respect for the court's time and your time, sir.
Don't worry about my time. Listen.
I'm
Listen to me.
severely
Hang on.
financially.
Hang on. Don't worry about my time. This is what I do for a living. I chose to do it. I still enjoy it. Do not worry about my time. Did you have a bad plate? You didn't have a plate.
I did not have a plate at all. I had insurance. I just bought the car that day. I have a clearance on my, from the court, from Woodhaven stating I had a license on the 22nd. I had,
Okay, so listen.
Judge,
What?
I just noticed that the B case is paid. She made a
Paid?
payment online.
Is that true?
yes, yes.
Oh, call in the prosecutor for me. Did you know that? You didn't.
I've simply paid so
All right.
much. I feel like.
All right, slow down. Come on. We're not that bad here. Just relax. Just relax. You haven't, would you pay $135?
I have receipts here.
No, on these, you didn't pay $600 on these cases.
135, Judge.
I have 3 different cases.
Oh, okay, but the different incidents, I mean, come on.
Understood.
What were those for?
So I had experienced a end of a very harsh marriage. I wasn't aware that my insurance was not being paid. It was supposed to be. So
Hang on a
for
second.
that.
Mr. Urich, your name? Your name?
Good morning, Your Honor. William Eric on behalf of the city of Woodhaven.
So she paid the expired plate.
Right.
Your Honor, in this circumstance, may I propose to be potential for my client to have the driving license suspended, dismissed. She's already paid the B ticket and then have the impede the traffic not.
Do you want to do that?
That's fine, Your Honor.
You change the stip form.
Of course.
That's fair, I think. I mean, if you paid the expired plate already, there's no reason for you to, for us to belabor this as far as I'm concerned. All right, so is that what we're doing? Is you're moving to dismiss, to suspend? And I'll just make a note, Mr. Urich, defendant paid file B, $135. So that acted as an admission. So you pled responsible by paying it and sending in your citation, okay? Well, I just want you to understand that conviction will enter. I'm dismissing the suspend, right, Mr. Urich, altogether?
Correct.
I've actually paid for that one as well. If there are any.
You didn't pay for this suspend.
$230 of the. Yeah.
On this case?
That was a 2024 case that was in warrant status.
That had nothing to do with this case, just so you understand.
It's worth the try.
All right, well, yeah.
If it was getting suspended and they had to pay for the.
The suspend charge is dismissed, okay? On this case, you're all set. You're confusing a lot of cases. You got to make sure you understand which case you're talking about, okay?
I appreciate your being so gracious.
Good luck to you.
Thank you.
Jeffrey Wasilewski, 25W839-262. Come on up to the podium, sir. Your name?
Jeffrey Wasilewski.
You have the right to a lawyer. You're charged with assault and battery. I'll be happy to provide you with a lawyer. Would you?
I have to pay for my own lawyer. I think I need too much money to.
No, I'm just telling you for purposes of arraignment, I have to offer you a lawyer. and I can give you a court-appointed lawyer, or if you want, I'll be happy to give you an adjournment for a couple of weeks so you can go and hire your own lawyer. It's up to you.
It's up to you.
No. I can't make that determination for you. I'm either going to adjourn this 2 weeks so you can, look at me, sir.
Yes.
I'm either going to adjourn this 2 weeks so you can hire your own lawyer, or I'm going to give you a court-appointed lawyer today for purposes of arraignment.
I'll hire a lawyer.
Okay, Lisa, we're going to adjourn this a couple weeks, okay? I'll just make a note, defendant will hire attorney.
You want me to plead back in?
I'm not even going to arraign you right now. I'll let you go and hire your own attorney, and we'll adjourn this to September 17th.
9:15.
At 9:15. You stay away from the victim. You understand me, sir?
Sure. How do I?
Hang on. One thing I probably should do is I'm going to go ahead and arraign. Okay? I will arraign you. I'll explain your rights. I'll set a bond. I'll explain. Just relax. I'm not going to do anything to affect you negatively. I'm going to give you a personal bond, but I'm just telling you, I will arraign you unless you want me to give you a lawyer for purposes of arraignment.
No, arraign me. That's what you got to do. That's what you got to do.
On August 5 of 25, the police think that you did commit the offense of assault and battery by assaulting and battering your neighbor, Mrs. Slayton. That is a misdemeanor, punishable by up to $500 in fines, 93 days jail, court costs for all of those penalties. Do you understand that?
Yes, I do.
And did you sign the advice of rights form and read it and understand it?
Yes, sir.
If you plead guilty, you'll be given all those rights, and there will not be a hearing or a trial of any kind. You understand that?
Yes, sir.
All right. So I'm going to enter a not guilty plea for you. You don't have to post any money. I'm giving you a $1,000 personal bond, but you don't have to post any money. So again, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed, starting with September 17th. You have to go and get fingerprinted. No contact at all with the victim in this case, Mrs. Slayton, whoever that is. You cannot write her, phone her, see her, text her, email her, or have anybody else do any of those things for you on your behalf. That's actually Tammy. Just let me finish, sir, please.
Well, I'll be able to speak. Maybe.
This is just an arraignment. You shouldn't say anything right now. You want to talk to your lawyer and let your lawyer take care of everything, okay? So no contact with Tammy Slayton, no contact with prosecution witnesses, no firearms. If you have any firearms or dangerous weapons, you have to surrender them to the Woodhaven Police Department, and you have to go over and get fingerprinted and photographed by 11 a.m. today at the Woodhaven Police Department. Do you understand that?
Yes, sir.
Now, I don't want to be accused of not letting you speak. I'm telling you, I don't think it's in your best interest to speak. If you want to tell me something, I'll be happy to listen to you, but I don't think it's in your best interest to speak. You shouldn't even admit you were in a scuffle or anything else. I'm not saying you were, sir. Okay, well, then you're certainly going to have a self-defense argument. There's no question about that. Talk to your lawyer about all of that, okay?
Yep.
And then go down the hall and get your notice. We're going to give you an order for prints. You have to go over to Woodhaven to get fingerprinted, okay?
Yep.
Good luck to you. You too. I wish you well. Thank you. Richard Allen Hanley Jr., 25W838922. I'm going to take that next with you there, Sergeant Driscoll. I'm going to finish this one up and then I'll come back there. Good morning.
Good morning, Your Honor. Stephen Shark on behalf of Mr. Haley. Nice to see you, Judge.
You too. How are you? Your name, sir? All right. I'm going to go ahead and take the plea. This is the plea as charged OWI, right?
Yes, Your Honor.
Is that what you want to do, Mr. Hanley?
Yes.
If you plead guilty here, the possible penalties are up to 500 fines, 93 days jail, 360 hours community service, court costs are all those 6 points. license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights form here today?
Yes.
Be plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Do you have any questions before I go on?
No.
This is a second offense, right?
Yes, sir.
To the charge operating while intoxicated, how do you plead?
No.
Were you operating a motor vehicle in the city of Woodhaven, County of Wayne on All near West at 2:06 in the morning on July 20 of 25?
Yes.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, sir. I did drink alcohol before that. We had
What
beers,
How many?
probably 3 or 4.
How big were the beers? I can't hear you.
There was the bugs, like the glass box.
I know, but were they more than 12 ounces? Were they 30 ounces?
Yeah.
So I take a stick with his blood alcohol was 0.15.
Okay, why were you pulled over by the police?
I think that I was speeding.
Do you think you were speeding, and you think you were speeding at least in part because of your alcohol consumption?
Yes.
Counsel, the results for, this was a breath test, was it?
Yes, John.
And the results were 0.151 I have?
Yep, that's correct.
And you so stipulate that was accurate for purposes of the plea?
Yes, Brian.
Are you on probation or parole right now, sir?
No.
Has anybody forced you to plead guilty?
No.
And accept your plea, I find it to be an accurate plea, made voluntarily and understandingly. Please accept that I do have to immobilize this vehicle. He owned it, so he has to be completed. I'll give you the minimum immobilization period, 90 days, and it has to be completed within 7. So by September 10th, you have to have that vehicle immobilized. My judicial clerk will prepare an immobilization order. I'm going to sign it, and you just have to have that club put on the steering wheel. Counsel, I see he had one that was nollie prossed back in 17. Does he have any desire to, and that's fine, so I'm not counting that. I'm just asking, does he have a problem that merits sobriety court?
That's the part of the whole thing.
I want you to talk to him about it.
Yeah.
And if
He probably would, Your Honor.
Pardon?
He probably would be interested.
You got 5 minutes to talk to him about it now? I want to send him over to probation and make sure he understands the program.
Okay.
And then you guys come on back in here. John, take him over there. I'm going to give him a screening and he's going to be screened and assessed today. And I want him to find out about the program. You don't have to sit around while he's screened.
Okay.
But at least come back in and because the sentence date's going to be different depending on whether he gets in sobriety court or not. So I'll let you take the file over to probation.
Okay.
We're going to, in either way, you tell him I'm just Judge sent him over there to see if there might be an interest in sobriety court. Okay.
I'll be outside. Okay, thank you.
Thank you very much. I'm gonna real quick take Robin Boynton the second. Robin Lewis Boynton the second, 25W839-319. B.
Good morning, Your Honor. Mr. Chairman, here get my client's name, set of the matter, being held in person, as the arraignment waiting will read my client can speak.
Your name, sir? Now he's going to plead to no ops, to suspend to be dismissed, right?
Correct.
You got to get a new license, valid license. You understand that? If you plead to no ops, possible penalties were up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
And did you sign, read, and understand an advice of rights form here this morning?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or trial. Do you understand that?
Yes.
To the charge, no valid operator's license on person. How do you plead?
Yes.
Were you operating a motor vehicle on July 25 of 25 in the city of Woodhaven, County of Wayne?
Yes.
Did you have a valid license with you on your person? Are you on probation or parole?
Excuse me?
Are you on probation or parole?
Yes.
Were you on probation on July 25th?
Yes.
By pleading guilty here, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction. You understand that?
Yes.
You still wish to plead guilty?
Yes.
Get both your search warrants. Has that anybody forced you to plead guilty?
No.
I'm gonna accept your plea. I'll accept the no ops. Dismiss to suspend. I'll send them now. Anything you'd like to say?
Your Honor, just that my client was under the mistaken notion that he had a restricted driver's license. However, it is suspended till the end of the year. He understands going forward that the Secretary of State and what was ordered in court are two different agencies of government. He understands it won't be duplicated.
Sir, anything you'd like to say?
No.
You can't drive on a suspended license. 100 fine, 70 costs, 75 victim charge, $50 justice assessment, 295 or 60 days. Can you pay that today?
Yes, okay.
You go down the hall, pay that, and we're all set. Any questions?
Yes. Can they take credit card?
Yes.
Okay.
Okay. Best of luck to you.
All right, thank you.
Thanks. I'll send them right out as soon as I read these guys.
That's Brownstown, that's in the Definitely already.
Your phone number ends in 1289?
Yeah.
Okay. I want to let you know that the alleged victim is in the courtroom and has spoke with me regarding the case. The charges that are filed against you as 2 misdemeanors and 1 felony. The felony charge is unlawful imprisonment under domestic violence. The misdemeanor is assault under domestic violence and disorderly conduct under domestic violence. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for 2 court hearings. One is for the felony and the other one is for the misdemeanors. I'll first talk to you about the felony.
Okay.
That's scheduled for a preliminary hearing on September 22nd at 4:00 p.m. A preliminary hearing is to determine if there's probable cause to charge you with that crime. Probable cause is what is required for charging, not convicting. If there's probable cause found at that hearing, your case will bind over to the Gila County Superior Court, and they'll take disposition on the felony portion of that. If there's not probable cause, then the case could dismiss regarding that felony. On the misdemeanor charges, I've scheduled you for an arraignment. That again is for the assault and the disorderly conduct charge under domestic violence. The arraignment is where you'll need to be prepared to plead either guilty, not guilty, or no contest to those charges. Depending on how you plead will be what happens next with the court process, and all of those options plus the penalty ranges will be explained to you prior to giving your plea at the next hearing. Okay. Your release conditions are the following: obey all orders of the court, do not commit any crimes, notify the court immediately of any address change, do not leave the state of Arizona without permission of the court, and I'm going to order not to have any person-to-person contact with the alleged victim. So that means not face-to-face. After speaking with the alleged victim today, I opened up the communication lines because there's the ability to say no communication at all. But I've opened up the communication lines to where you're allowed to make phone calls, you're allowed to text message, okay? As long as that is not unwanted. If it's unwanted, or if she requests not to call her or not to text her anymore, you must comply with that request, or you're violating this court's order and you could be arrested or a warrant for your arrest. Do you understand that condition?
Yes.
All right. And then the final condition is to not possess any firearms. And then I'm ordering you to pretrial services. So what that is once you're released from custody, I'm going to provide you a phone number and name to the probation department. You're not on probation, but you are on release services. I plan on releasing you on your own recognizance, so you'll be getting out of jail today, but you are required to call them right away, and they're expecting your phone call. Their job is to monitor you to make sure you're complying with these release conditions and make sure you're going to your court dates as ordered. So they'll tell you what to do to check in with them and call them throughout the week and let them know what's happening. Do you understand those release conditions?
Yes.
Can you comply with them?
Yeah,
And you'll show up to court as ordered?
yeah.
All right, I'll release you on your own recognizance with that agreement. Do you have any questions?
No.
Okay, that's all I've got.
Okay.
You betcha. I'll get it sent over in a few minutes. I got to call Globe and then I'll get it over. You bet.
Okay, Joe, can I help you?
Hi, Judge Garvin Payson. How are you?
Judge Garvin, good, sir. How are you?
I'm doing well. I was wondering if I could see Angela Rodriguez Cordero.
Yeah.
All right.
I'll bring her in to call you in about 2 minutes.
Okay, I'll be standing by.
Sounds good, sir.
Thank you. Bye.
Give me a date, Lisa, for a sentencing on this.
17th at 8:30.
At 8:30, good with you? This month, September 17th, yeah.
Yeah, sure, that should be fine.
Okay.
We have one request. You got an alcohol tether,
Soberlink.
Sprite Soberlink. Can he switch that to an alcohol tether?
I don't care. Where does he work at? I just don't want to hear any environmental factors causing it. So, and counsel, it's more expensive. I'll write down here. So if you guys want to go talk to probation about fees, defendant can use SRAM tether instead of SoberLink. So you can go talk to him about that. I mean, instead of SoberLink device, I don't care, but it's going to be more expensive.
Okay.
Okay?
Thank you.
Have a good day. Good to see you. Good luck, sir. Miriam, Bezim Syed, 25W839. 539. Could I have the Quandra Gee seated up at the table? Good morning, counsel. Your appearance?
Good morning, Your Honor. For the record, Ziad Nicholas Abu Zaid on behalf of the defendant.
How are you doing today? Good?
I'm well, Judge. Thank you for asking. We're alive and breathing. Thank God.
All right, so this will be a plea to impeding, and then they're going to dismiss the limited access charge, correct?
Yes, Your Honor. Upon your approval, I do have the authority to plead responsible to that amended charge.
All right, to that charge, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted, speeding's dismissed, pay by September 10th, $180, okay?
Thank you, Judge. Always a pleasure.
Have a good day. Take care. Thank you. Weddington, Pamela Joyce Weddington, 25W8394678. Your name, ma'am?
Pamela Weddington.
You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Yes,
Okay, we'll give you a lawyer. Go out in the hall. We'll set you up. How's that?
that's great.
Go right out in the hallway. Thank you. And then either way, you're coming back in front of me today, okay? DeQuandra Gee here? Where's DeQuandra Gee? Do you know, Lisa?
It was a walk-in for time to pay.
I know, I don't see him or her.
Unless she went in the hallway, maybe?
What's your name, sir? Gibson?
No, that's.
Philip Devon Gibson Perry. 25W8394178 B and C. I don't know what's going on out here. Where are people at?
Judge, he's coming in.
Cody Reamer? Come on. Vince?
Sure.
I don't know what's going on out there, but I need Cody Reamer in here. If you can write this down. Cody Reamer,
Reamer,
DeQuandra Gee, Philip Gibson Perry.
Gibson Perry's on Zoom.
Yeah. All right. So you don't need to worry about him. We're in Alexis Myers if she's out there. Okay. No, she's not. Just the first two you need to worry about.
Okay, wait, that was Reamer then and who?
DeQuandra Gee.
D, okay.
Thanks.
And I do know D was here, but all right, I'll let you know in a couple seconds.
Thank you.
Yes.
Did you have a lawyer, ma'am?
I spoke to an attorney already.
The prosecutor or defense lawyer?
Ms. Myers.
She's an arraignment.
Did you speak to a defense lawyer or a prosecutor, ma'am?
Judge, she's not spoken to me.
All right. Why don't you guys come on in here? Let's get some of these done if we can, okay? Which one do you have? Counsel?
Person, do you want me to walk in there, Judge?
What do you have? What
I have
cases?
Myers, Judge.
Who? Myers?
Myers.
I can't hear you. Myers?
Yes. Do you want me to come in there, Judge?
No,
Might be
Alexis
easier.
Myers. Alexis Colleen Myers. 25W837-906. A, B, and C. All right. Your name?
Alexis Myers.
Jeez. Your appearance, counsel?
Good morning, Judge. Madden Gates appearing on behalf of Ms. Myers.
So she has a misdemeanor and 2 civil infractions. On the misdemeanor, she's standing mute and waiting formal reading.
Correct.
I don't know what's going on. I got to have you in here. I don't know what in the world is going on. You're cutting in and out.
I'll be
Come
in
on
there. I'm
here,
coming in,
please.
Judge. Thank you.
I'm entering a not guilty plea on the drive while unlicensed. You have 2 other charges here. No proof of insurance and expired plate. Okay, just relax. Let me wait till your lawyer gets in here. Ma'am, I'm going to have you have a seat right there at that table. Have a seat.
Right here.
Right there. DeQuandra Gee. DeQuandra Sharna Gee, 23B144404. You can come right up that way if you want. Come on. Could I have Cody Reamer up here at this table? Your name, Ms. Gee? Where you been? You're coming in for time to pay? This ticket was issued back in October of 23. Really? Come on.
It's been a lot of one.
Yeah. Do tell. What's been going on? You work?
I just actually started working.
When did you last work before just starting work?
I haven't been working a while.
Why?
Because I was disabled.
How much do you have today?
I didn't bring any money today, but I can get some money if I have to. That's why I'm trying to get a payment.
You've had a payment plan. You set up your own payment plan. You've been on a payment plan for 22 months. You've been ignoring us.
I never been.
Man, the ticket was issued in October 23. You've never come in front of anybody, any judge in this courthouse, have you, on this case? Okay, well, you just kind of gave yourself a payment plan. You just said, I'm not showing up there for 2 years. Dad, how much can you come up with today? Tell me how much you can afford to pay weekly or bi-weekly.
Bi-weekly. I was trying to do monthly payment.
I cannot hear you.
I was trying to do a monthly payment.
Well, tell me how much you can pay a month.
Well, this month, you keep it next month 100.
When can you pay the 50 and when can you pay the 100?
I could pay it to the fee today.
All right. And can you pay 100 a month beginning September the 3rd or October the 3rd? Yes?
Yes.
You sure? That's what I'll order. 50 beginning today, 100 per month beginning October 3 and the 3rd of every month thereafter. Now listen to me very carefully. If you don't have the money, no problem. But you got to extend a courtesy to court. You come in here, talk to me on or before the due date, or call up and say, I need to speak to the judge on Zoom on or before the due date. I'll be glad to work with you, but stop ignoring me. Okay?
Yes.
Fair?
Fair.
All right. Have a good day. Good luck. Alexis Colleen Myers, 25W837906, A, B, and C. Your name, ma'am?
Alexis Myers.
Mr. Gates?
All right, about Ms. Myers.
She stands mute, waives formal reading. True? And now the prosecutor is going to have her plead to
Guilty to the A and B citations, judge will dismiss the C citation. I'm sorry.
why is he writing down no?
He'll dismiss the no license and he'll amend that to allowing. And then she'll plead to the expired plate.
Well, I don't even need a plate. Please, she hasn't been here. So I'll dismiss on motion of the prosecutor. I will dismiss the no proof of insurance. She still has to pay the $45 clearance fee on that case to have that suspension lifted. And then I'm going to go ahead and she's already been in default on the expired plate. So I'll just address payment terms. I'll dismiss the drive while unlicensed. If she pleads to allowing unlicensed driver to drive, is that what you want to do?
Yes.
If you plead to that, the possible penalties are up to 500 fines, 90 days jail, costs of all those. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
To the charge, allowing an unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a motor vehicle that was being operated on March the 4th of 25 in the city of Woodhaven on Allen near West?
Yes.
Did you allow somebody to drive that was unlicensed, and was that you?
It was me. Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Plea is accepted. The driver unlicensed is dismissed. The expired plate conviction will remain in full force and effect, and I'm going to dismiss the no insurance charge pursuant to stipulation. You drive without insurance. What do you want to say, Mr. Gates? Anything?
That's just that there was financial issues with regard to her failing to appear judge. Didn't really she had moved from that address where she was staying. But she did walk in on her own volition, judge. She doesn't want to take care of these items, these charges and get everything in order. So I'd like the court to take that into consideration in assessing any fines.
Where do you work?
I just started back at 4. I was laid off.
Okay. Good. Anything you want to say?
No.
I'm allowing an unlicensed driver to drive, 100 fines, 75 costs, 75 victims' rights fee, $50 justice assessment, 300 or 60 days. The no proof is dismissed. You still have to pay the clearance fee. You owe $45 on that. And on the expired plate, you owe $213. Can you pay all that today?
Yeah.
I'll tell you what, I'll reduce the balance on the expired plate, Lisa, to 190 to 190. Balance reduced to 190 on the expired plate. So you pay 190, I'll waive the other $23. The no proof, you have to pay 45 on. So you can pay 190 plus 45 or 235 plus your 300, 535. You'll walk out of here with a clearance. Any questions? I wish you well, man. Good luck. People against
Aye.
Okay, good luck. Donald Earl Hudson, 25W83858 A and B. 585 A and B. And then I'm going to take Reamer. Your name, sir?
Donald Earl Hudson.
Did you have a lawyer?
Yeah, I get somewhere.
I need these guys in here, man. Who was it? What did he look like?
Black guy.
Mr.
Judge,
Crawford?
he's in Zoom with someone that's in custody.
All right. Go have a seat. I'll be right with you. Mr. Reamer, did you have a lawyer?
He's also my lawyer.
These are both Mr. Crawford.
Judge,
How
do you
about
still have
Gibbs-
Oh, sorry.
How about-
Okay.
How about Gibson Perry? Where's Gibson Perry?
He's
at?
on Zoom.
Philip Devon Gibson Perry.
Yes, sir.
5W839417 A and B and C. Your name, sir?
Philip Gibson Perry, Philip Devon Gibson Perry.
You're charged with driving on a suspended. You have the right to a lawyer. Would you like a lawyer? I gotta see your face, sir. I
I'm
don't want to
sorry.
see a
I was trying to hear.
That's all right. Would you like a lawyer to represent you on this?
I think I'm fine.
Okay, so you want to waive your right to a lawyer and I'll arraign you and then put you in a room with the prosecutor?
Yeah.
All right. On August 7 of 25, it is alleged that you did operate a motor vehicle on I-75 near Van Horn and Woodhaven with a suspended license that is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs are all those 2 points. You have a second charge of expired plate. That's a 0-point civil infraction. You have a third charge of limited access violation, 93 and a 70. So 2 civil infractions, 1 misdemeanor. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
I really kind of want to talk to my mom because I was trying to.
Slow down. Slow down.
Sorry, I was trying to.
Slow down. Wait a second. I don't want to talk about the case right now. If you want, I'll enter a not guilty plea. You can go talk to your mom. I'll set it for a pretrial, and we'll have you back for another date. And if you want a court-appointed lawyer, then you're going to have to get a hold of my judicial. Hang on.
All right.
Just let me finish.
Sorry.
Then you'll have to get a hold of my judicial clerk. I'm going to give you her phone number, and she'll send you a petition for a court-appointed lawyer, okay?
Yes, sir. Thank you. Yeah, that's what I would like to do.
Pull out your pen. I'll enter a not guilty plea, $500 personal bond. You can leave the state without consent. You live in Akron, right?
Yes, sir.
You cannot violate a law. You must appear in court as directed. I'm going to give you a court date. We're going to give you September the 17th. At what time, Lisa?
9:30.
At 9:30. Here's her phone number, 734. Or do you want me to do it another way, Lisa? Whatever's easier for you.
You can give him my phone number. That's fine.
734-671-0201, extension 230.
Wait, you said 734-671-0201.
01.
Okay.
Extension 230. If you decide you want a court-appointed lawyer, you get a hold of her. She'll send you the form. You fill it out before you come back.
Okay. Thank you very much. Yes.
See you here on Zoom. Good luck.
Thank you.
Thank you.
So am I free to leave?
You're all set.
All right. Thank you very much. Have a good day.
You too. Thank you. Good luck.
Thank you.
Logan Scott Davis, 25W839209, A, B, and C, 25W839200A. Oh, no, that's a different Davis. That's John Earl. So I just have Logan Scott Davis, 25W8392009 A, B, and C. Mr. Bulahanis?
Good morning, Your Honor. Greg Bulahanis, P 36431, on behalf of Logan Davis. Your Honor, he hasn't been arraigned, I don't believe, so we waive the formal reading of the complaint. Stay on mute.
Sir, your name?
Logan Davis.
I'm going to enter a not guilty plea, indicate he stands mute. He has a prior 4 or 5 years ago, right?
Yes, Your Honor. And this one is a .08. I'm not going to get into the issues right now, but it may not even be .08.
All right, I'm going to give you $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. How old is he?
22 years old.
22, Your Honor.
AA at least, NA at least twice a week you have to go. AA, NA at least twice a week. No alcohol, no marijuana, no illegal drugs, no contact with prosecution witnesses. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. We're going to adjourn the pretrial for 4 weeks, Lisa. All motions to be filed. So you're giving me what, October?
1st at 8:45.
Hold on 1 second. October 1st. Could we do a little bit later that morning? Is that could be the hearing date, Your Honor?
Yeah. We can do it. We're not going to do 8:45 anyway if it's a motion. We'll set it for 11 a.m.
Okay.
All motions be filed and heard October 1. Motions to be filed. That'll be at 11 a.m. Motions to be filed by September 17th.
Thank you, Your Honor. Your Honor, there's going to be video on this. So do I need to contact?
Wait a minute. What do you mean video? It's going to be video. Is this an evidentiary here? What are you going to ask for?
Yeah, it's going to be an evidentiary hearing.
Well, I want you to appear in person if it's an evidentiary hearing.
Oh, yeah. No. Yeah, I agree, Your Honor. So I just wondered.
Call in the prosecutor. Go ahead.
Should I contact, is there an expert setting up the video? Because last time he said, give us a little lead time if you're going to be playing videos and stuff.
Yeah, you get a hold of a 671.
They can send it to me and I'll just screen share.
Yeah.
Oh, okay.
All right.
Okay, just send the Lisa. Okay.
Yeah, so we'll have the hearing October 1 at 11 a.m. Motion to be filed by September 17th. Reply brief due by September 24th. Do you want to tell him who you want? Good morning again, Mr. Urick. Your appearance?
William Urick on behalf of the city of Woodhaven.
He wants to file a dispositive motion. It's going to be an evidentiary hearing October 1 at 11. October 1 at 11. That's your docket. He has to file this motion by September 17th. You need to file a reply brief by September 24th. Do you know who you want here?
Yes, the arresting officer, who is also, I believe, the officer that did the breathalyzer test at the police station as well.
Now, Your Honor.
So is this more about, hang on 1 second. Is this more about you're not going to throw the kitchen sink. Hang on.
No.
Hang on. Are you going to argue that the stop was bad or the breathalyzer test was improperly conducted?
There's two motions that would be filed, Your Honor. One, that the breathalyzer test at the station was not done according to the regulations, number one. Number two, I'm going to be filing lack of probable cause for the arrest.
Okay. So we're going to need the arresting officer and the breathalyzer operator. He seems to think they're both one and the same.
It appeared that they were one and the same.
Okay, good enough. So we'll have that on October 1 And again, those are the rules. File by September 17th, reply brief due September 24th.
Thank you so much.
The evidentiary hearing is to be conducted on October.
Correct, at 11 a.m. And we're going to want the officer present, and don't wait until September 28th. If he's not available or she's not available, I didn't see who it is, I'll reschedule it right now because I don't want to put these out too long. Okay?
Thank you very much.
Have a great day. Anything else, Mr. Boulahanis?
No, Your Honor. Thank you
You're
so
going to
much.
give your client an AA form. He's going to go in person just to
I've
be
got
clear.
it. I've got it right here for him.
Have a great day. Thanks.
Thank you so much.
John Earl Davis. Is John Earl Davis here, Lisa?
Not on Zoom.
Q5W839200 A and B.
I don't think he checked in. I think they confused him with the other Davis. We have 3 today.
So we need to, he sent in all Davis files. It might have been. I'm going to find out from Mr. Crawford if Mr. Davis is here. Tell him I'd like to come in, have him come in as soon as he's available to handle Hudson, Weimer, and Davis.
He's not Zoom for Monroe County Jail.
All right, well, I don't have anything else ready, so I'll come out as soon as I do. Everybody stay seated, please.
Over Davis, this one's done. Gibson Perry's done. He just got, oh, I'll be right.
Disturb the peace.
Correct.
Is that what you want to do, Mr. Reamer?
What was that, sir? Yes, sir. Yes, sir.
To the charge of noise violation, responsible or not responsible?
Responsible.
Please accept and disturb the peace is dismissed. 150. You can go down the hall and pay that, and you're all set.
You pay that today? I get paid tomorrow. Can you pay tomorrow by the
Yep. Pay tomorrow by 4 p.m. Okay,
Yes, sir.
that's September the 4th. Okay, good luck. Donald Earl Hudson. 25W838585 A and B.
Morning, Michael Rock, representing Mr. Hudson.
Sir, your name?
Donald Earl Hudson.
Sure. Wow, he's pleading this to improper plate and have leave the scene. Boy, they're getting nice back there. Anyway, is that what you want to do?
Yes.
It says defendant responsible for any damage to property per restitution. I don't know what that means.
He's going to plead guilty to the improper play and be responsible to whatever restitution might be. He hit a fence, so it's some.
All right, so first of all, for purposes of arraignment, does he stand mute, waive formal reading?
Correct, bro.
So what am I supposed to do on this?
Oh, we're presenting an agreement, Your Honor, where you dismiss.
I get it, but are you guys going to look into the restitution?
Correct. So I guess we set a separate sentencing day.
All right. If you plead to improper plate, I'll dismiss the leave the scene. The possible penalties are up to 100 fines, 90 days jail, costs for all those. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yeah.
Lisa, I want to make sure we notify the victim. I don't know if you're going to do that or probation, but somebody's going to have to. To the charge improper plate, responsible or not responsible?
Responsible.
I'm sorry. Geez, what am I thinking? To the charge of improper plate, guilty or not guilty?
Yes.
Were you operating a motor vehicle at 20200 Hayden Drive near Allen in Woodhaven, August 5 of 25 at 2:25 p.m.?
Yes.
Do you have an improper plate?
Yes.
Are you on probation or parole? And you understand as part of this agreement, even though I'm dismissing to leave the scene on the motion of the prosecutor, you're going to have to pay restitution if any's owed on that damage. You understand that? You still wish to plead guilty?
Yes.
Anybody force you to plead guilty?
No.
All right, I'll accept your plea to improper plate. Dismiss to leave the scene. Lisa, make sure that victim's notified. Do you want to make it next docket or you want to make it the one after that, Lisa?
September 17th at 8:30.
Okay, September 17th at 8:30 in the morning, sir. Do you understand that?
Yes.
Go down the hall, get your notice. We'll see you back here. And I'm giving you a personal bond of $100, if I didn't already say that. $100 personal bond. You cannot leave the state, cannot violate a law. You must appear in court as directed. Any questions?
No, sir.
Sir, I wish you well. Good luck. Go down the hall, get your notice. We'll see you back here. Quentin Gee. Quentin Deshaunway Gee. 215-W803-902.
Well, Your Honor, I'd like to call the representative to Hayden with approaching. Substation for the record.
You're going to plead the impeding?
Yes, Your Honor, the original child is dismissed.
Jeez. All right. 10 years later, he shows up. To the charge of impeding traffic, responsible or not responsible? Plea is accepted. 220 is your total. The suspend's dismissed. You have a bond. It looks like a 134. You're going to have to go down and pay the other 86.
Getting up to the end of the day tomorrow on this page.
Pay 134 now. That's the bond. Pay the rest by September 4th. We close the doors, so you should be here by 4 o'clock. Okay? Good luck. Wish you well. Thank you. Destiny Danier Henry. 25W837840. Can you finish up whatever you have, counsel, and bring it back in here and we'll get.
Yes. Or not, Your Honor.
Good morning, Your Honor. Mr. Shanky, Barry, I'm
Ma'am, your name? Wait a minute. All right, so you're very soft spoken. That's okay. But you got to keep your voice up for me, all right? So she's going to plead the destruction of property under HIDA.
That's correct, Your Honor. She's 22.
And is that what you want to do? If you do that, the possible penalties here are up to 500 fines, 90 days jail costs, or all those. I'll defer the proceeding taken under the Homes Youthful Training Act. We'll set it for sentence. If you're compliant at the end of the specified period of time, which they've agreed upon is 12 months, the case will be dismissed on motion of the prosecutor. Do you understand that? You got to keep your voice up. And you understand all your rights? Did you sign an advice of rights form today? She did not, did she?
No, I believe she might have signed one of the original arraignment.
That's not good enough. And take your time, sign this advice of rights for me, please. Make sure you read it and understand it. Go off the record. In fact, why don't you have a seat there? I'm going to go on to Weddington, Pamela Joyce Weddington, 25W839-467A and B. Your name, ma'am?
Pamela Weddington.
Mr. Shemke?
Good morning, Your Honor. Mr. Shanky, Barry, my client statements on my left as to the arraignment away from reading my client's statement.
All right, ma'am. I'm going to give you a personal bond, enter a not guilty plea, $500 personal bond. You cannot leave the state without consent or violate a law. You must appear in court as directed. When are we going to set this for, Lisa? September 17th?
Yes,
Yeah,
9:45.
I guess potentially, she's working with another attorney to get,
That's fine, but don't ask me to adjourn it again. I'll go to October 1. I'll go to October 1 at 9:45, okay? October 1 at 9:45. I mean, I might consider another couple weeks, but.
I understand that.
Okay, so I'll give you that. You're going to go down the hall. You're going to get your court date, your written paper notice. And if you want a court-appointed lawyer going forward, you're going to have to fill out a petition for one, okay?
Yeah.
Thank you. I wish you well. Do you have any questions?
No, sir.
Good luck. People against
Thank you.
Destiny Daniel Henry, 25W837-840.
Good morning, Your Honor. Mr. Shanky again. You have my client.
Ma'am, your name again? Do you understand everything I've said so far? You understand, nice and loud?
Yeah.
You understand the possible penalties? You understand you pleading guilty, you're giving up all the rights on the advice of rights? Have you now signed that document? Did you read it and understand it? All right. Do you have any questions before I ask you how you plead? To the charge destruction of property, how do you plead? Were you on Reek at 26530 Reek Road, apartment 263 in Woodhaven, June 24, 25?
Yes.
What did you do that makes you guilty of destruction of property?
I explored this car in the machine.
All right, and you intended to kick it, correct?
Yeah.
Are you on probation or parole?
She had, Your Honor, I spoke with Ms. Tessino regarding it. She's already been violated. So there's, Ms. Tessino indicated that she had to do some work program days. She's already been in compliance with that. And before we even continued with this, I brought that to the attention of the prosecutor. And she's in a unique position to be able to walk away with this with some anger management classes, a no contact provision, and potentially legal history.
So was she violating on the violation of law?
Well, she was violated on the no contact provision, and then I told Ms. Tessino what we were doing today. She already indicated what her intention would be to discuss the matter with Judge Hessen, but she anticipated that the probation would run concurrent.
Okay, but you do understand Judge Hessen's going to make up her own mind, right, ma'am? That you might have your probation revoked. I'm just saying, as a result of this plea and conviction, and you could be incarcerated on that charge as a result of this plea and conviction. You understand that? You still wish to plead guilty? I'll take your plea. I find it to be an accurate plea, made voluntarily and understandingly. Was there any alcohol involved?
No.
PSI sentence date will notify the victim on this one. And you're going to go over across the hall. You're going to be interviewed, and then you'll come back for sentence. When do you want to do this one, Lisa?
October 17th at 8:30.
September 17th at 8:30, okay? September 17th at 8:30. All right? You understand everything? Okay, good luck. Thank you. We'll see you back here then. Do we have anything else here right now?
No, sure.
How's everything?
Keeping busy, Judge. Started back up at the Fire Academy. So I have that tonight. I did Fire Academy 1 and my husband, so I'll do the Fire Academy 2. So
Nice.
December.
Good.
It's funny, so I was the captain. So it's paramilitary. So there's 3 platoons, 3 lieutenants, 1 captain. So I was captain last semester, and I wasn't even going to be captain. I wasn't going to ask for it. But the chief came, he goes, "Why aren't you applying for this position?" I said, "Well, you indicated that there's a shortage of firemen, and there's actually chiefs who come to the academy to look for firemen. And you know that I'm doing this as a volunteer." He goes, "I don't care about that. I want to be captain." So I did it last semester. And then this semester we come and you have to apply for positions. Now I've got acquainted with the job. I wouldn't be anything less. It's like, I'm not doing a demotion. But the chief, he goes, "Well, just so you know, sometimes we like to spread it around, so no promises." So first day of class was Wednesday, and there were some administrative things that needed to be done. So I already got ahead of that. I didn't charge for everyone the whole summer. Like it's a good group of people. And I go back and we talk to the chief. He goes, "Well, it looks like you're going to be captain again. You guys already doing stuff?" He goes, "No, actually, no one else wanted that position. Like you were," which made me feel pretty good that, my entire team, they wanted to keep it the way.
Nice.
So it's just, it's fire.
Nice.
Good.
Good for you. Kenyatta Davis.
Yes, sir.
Kenyatta, and I need all the sentencings. Kuru Davis II, 25W8378846, 25W8388014, 25W8378845. 25W8383552, 25W8383232, 25W837440.
Morning, Your Honor. Michael Crawford, representing the defendant, Quarters 3 cases that are yours and 3 for Judge Hessen. But there is a universal deal that's been presented to the court that will address all the cities.
You're in treatment now?
Yes, sir.
Yes, sir. You sent the treatment back on August 20th, I believe.
All right, so I'm going to take a plea on retail fraud. This is on. So I can't read this. Which one am I taking?
Well, it's going to plead guilty to all 3 of the cases before you, which are the top 3. And the others will be dismissed. I can write down Hessen.
No, I can take that. Okay. I see. He filled out different stip forms, did he? What is going on? I don't even see the stip form. I see one stip form. It says he's going to plead guilty to retail fraud on the April 4th one. I don't see anything.
Second one is dismissed.
Oh, I see a second one on the dismissals, but what about the other two? 25W8388014. Wait a minute. Target February 8th. Can't even read this. Oh, I see. He wrote it up the side. So he's pleading, the defendant's pleading guilty on all the cases in front of me. They are from July 9 of 25, on April 4 of 25, and on July 8 of 25. True?
He's pleading no contest, yes.
Why no contest?
Lack of recollection, he's had a bad drug problem at the time. He does not remember what was going on.
You don't remember any of these? Did you guys bring me these? And
No, Judge.
hang on. You guys will help me if you pull out the police reports for me. I have no clue what file or files these are in. I'm going to ask you to pull all those police reports. And I don't know if they're in there, not in there, and then I'll go ahead and take the plea. Go off the record.
You want me to go back on that doesn't even.
Sure. People against. Derek Arthur Shulman, 25M 577 571A. Defendant failed to appear. Show cause. This is on Judge Hesson's. Or I guess it's my case. Warrant to issue. 3,010%. Yeah, these are mine. They were transferred over with the state doc. Default judgments entered yesterday for failure to appear. People against Laskowski. Eugene Francis Laskowski, 25W838939, A and B. An issue a show cause on the B file and on the A file. Default judgments entered for failure to appear. Blair. Lisa Marie Blair, 25W838228. Defendant failed to appear. Issue a show cause. Jason Andrew Bartel, 25W839334 A and B. Defendant failed to appear. Issue show cause. Hooks. Keyshawn Deswan Hooks, 25W839402 A and B. Defendant failed to appear. Issue a show cause on the B file. Default judgment on the A file. Watt, Daniel, Mart, Amos, Watson, 25W838411. Defendant failed to appear. Issue a show cause on that. Mazar, Nadal, El Halawala, 25W839, 293, A, B, and C. I'm going to issue a warrant on the failure to appear in the misdemeanor file, which is file C. Default judgments were already entered on the A's and B's. El Jaha. All right, all these are show causes, and I'm going to run through these real quick. Not here. People against Defala, Muhafa, El Jahaf, 25T645-379B. Warrant issue 282 cash or surety. On 379A, that's 25T645-379A, 213 cash or surety. Tyrone Edwards Armstrong Jr., 25W838-625, 213 cash or surety. Anthony Antonio Jerome Arnold II, 25W838-624, 282 cash or surety. Jordan K. Bland, 25U567364, warrant issue 279 cash or surety. Andrew Michael Bouchard, 25W838-476, 213 cash or surety. Christopher Ian Burr, 25T645-432, 213 cash or surety. Chapman, Andrew Chapman, 25W838-643, 237 cash or surety. Jacob Robert Dillon, 25T645-403, 282 cash or surety. Rachel Catherine Eves, 25B148450. Mr. Crawford, don't go too far. 237 cash or surety. Rise Ronald Graham, 25W838-617, 213 cash and surety. Shaquila Charmaine King, 25W838-529, 237 cash or surety. Christopher Michael Cleast, 25B148619, 285 cash or surety. Regina Elizabeth Miller, 25W838-113, 195 cash or surety. Kalaya Danielle Price, 25G306456. 13 cash or surety. Larry Michael Provost, 25F243891, 213 cash or surety. Gagandeep Kaur Seacon, 25F243889, 237 cash or surety. Damon Lenice Marie Smith, 25W838-635A and B. Those will be warrants and bonds, 135 and 282 cash or surety respectively. Aljani Latman Williams, 25B148618, A and B, 213 and 282 cash or surety respectively. April Lachey Chavis, 25B147401A, Bennett failed to appear on September 3. Warrant issue 405 cash or surety. Carrie Lynn Andrew. I need to talk to the prosecutor about this one. 25W837427. Defendant failed to appear. I don't know what this person's doing here, counsel. Your appearance?
Michael Crawford, person of the defendant.
Well, first of all, you guys agreed to take it under 771.1 for 18 months. So.
I'm sorry, Your Honor. Oh, we defendant, are we on the?
This is Carrie Lynn Andrew.
Should be short. Shots. Down.
So your appearance?
Good morning again, Your Honor. William Merrick on behalf of the city of Woodhaven.
Arrested defendant was in Dearborn for possession of controlled substance and possession of drug paraphernalia. Arrested in Wyandotte for loitering. That's from November of 24. Arrested in Wyandotte for loitering where drugs are present. In possession of drug paraphernalia. There's another warrant out for possession of narcotic equipment and possession of marijuana. And then has a warrant out of Osceola County for neglect of child and child support. I can't take a plea under 771 for 18 months. So you guys sent this in. Listen, this isn't today. You sent it in on April 30. And the defendant didn't show up. And I noticed it was for 18 months on the STIP form. I'm not saying you did it. I think it was somebody else. But I can't take a 771 plea for 18 months. Second, I need to know what these others are about. If this is a fourth and just there's been no convictions because they didn't show up before, I'm not taking this under 771.1 with all those prior drug convictions, this being a drug dealer.
Sentence.
Yes.
Oh,
That being said, defendant just forfeited 7,500, 10% bond by not appearing. So what happens then? Well, it's just going to be doubled, 15,000, 10% on Carrie Lynn Andrew. I'm going to need you in here on the one case here very shortly, Jeremy Shaw.
yes, sir.
So I'll call you when it's necessary. Thank you. Anthony William Rose, 25W385886. Defendant failed to appear on this, right?
Yes, sir.
Issue show cause. All right. Let's go back on Kenyatta Davis.
Judge, do you need each one of these to the?
Yeah, Mark. I don't know if I like this. Kenyatta, Carew, Davis, the fifth.
For purposes of entering the plea. Should not make a huge difference unless she has a lot of trouble. Then this kind of hamstrings us. If she does have any idea what I'm talking about, probably not. I'm not sure your attorney has any idea what I'm talking about. Maybe I don't either. That's attempted humor.
What?
That was an attempt at humor.
Oh, okay.
Anyway, maybe I'm not as funny as I think I am. So what you're looking to do is to try and have her plead to a charge of operating with a high BAC.
Yes, Your Honor.
High BAC carries with it the possibility of 183 days in jail and a fine of $700. That doesn't really matter because in order to participate in our program, you would basically have to be subject to having a fine and costs delineated by the program. And that's a little bit more than what it is that, actually it's a lot more than you would have to pay if you were not in the program. But my recollection in reading your information is that you're unemployed.
Yes,
So you don't have the ability to be able to make a payment in any regard. Is that right?
I have money to be able to pay.
You do have money to pay. Is that true?
Yes.
Okay. So it's the difference of a couple of $1,000. Looks like there's $216.
Your Honor, I did see according to the notes on Jesse's end that she does have active Medicaid, so I don't know if you'd be willing to find her indigent as a result.
You know, you're always messing with me.
Well, I'm just trying to keep you from doing paperwork that I'm gonna bring you paperwork and try to undo. I'm just trying.
She said that she has money.
There could be other things that we could use her money to facilitate.
Well, we could not do that. She could do that.
Yes, we could strongly encourage her.
So Noble, I don't know if you want to weigh in here.
If I could may provide some insight, Judge. Ms. Crum is financially supported by her parents. She does reside with her mother, and her father lives separately, but she is his primary caretaker to help with his groceries, taking him to medical appointments, making sure prescriptions are filled, making sure groceries are supplied at the house, things of that nature. So while her employment is not traditional in the sense of how we understand employment, she does have financial support for the caretaking duties that she undertakes.
Okay. So on the strength of that, I could potentially say that financing costs would be adjusted because it's not her real income that she has. It's basically being provided by parental support. So basically what you would like for me to do is dismiss count one, have the defendant plead guilty to an added count of IBAC. Is that right?
That is correct, Your Honor.
So you understand that that is a significantly different charge than the one that you're facing right now.
Yes.
So understanding that you could potentially go to jail for up to 182 days and have a fine of $700. But again, that's as we've been discussing, that's not really an issue in this case. But your license would be suspended. There'll be points placed on your record. That's probably going to make your insurance costs go up and things like that. So understanding that, do you still want to go forward with the entry of the plea?
Yes.
You do understand that if you're already on probation or parole at this particular moment, that this could be a violation of your supervisory status with another court.
Yes.
You also understand that if you're not a United States citizen, you pled guilty to an offense, that you can be removed from the country because of having this conviction.
Yes.
So understanding all of that, you still want to go forward with the entry of the plea?
Yes.
Raise your right hand. Do you swear or affirm that the information that you're going to provide to the court will be the whole truth?
Yes.
Lower your hand. I want to make sure that you're doing this voluntarily. Has anyone threatened you or forced you to get you to do this?
No.
Has anyone made any promises to you to get you to do it?
No.
So you're pleading guilty because you are in fact guilty?
Yes.
And this is your own personal choice after consulting with your attorney?
Yes.
The attorney's been able to answer all of your questions and address any concerns you've raised with them.
Sorry, I didn't hear.
Your attorney's been able to answer all of your questions and address any concerns you raised with them.
Yes.
Mr. Noble, if you would like to inquire of your client.
Yes, Judge, thank you. Before I do so, I might add that Ms. Crum is on probation out of Acosta County for a offense that occurred after the date of this offense. So my understanding is that it shouldn't have any issues with the probation, but just for the court's edification, wanted to put that on the record.
What's the charge that she's on probation for?
It was domestic violence. With that, I'm going to proceed with the factual basis. Thank you. Ms. Crum, on January 2nd, 2025, were you operating a motorized vehicle?
Yes.
Did you operate that motorized vehicle on Doncaster Avenue?
Yes.
To the best of your knowledge, is Doncaster Avenue located in Holt, Michigan?
Yes.
And is Holt, Michigan located in Ingham County?
Yes.
On that date and time, before operating your motorized vehicle, did you consume alcohol?
Yes.
And to the best of your knowledge, is Doncaster Avenue open to motorized vehicles in the general public?
Yes.
And on that date and time, were you involved in a property accident?
Yes.
And the police responded to that accident?
Yes.
And when the police responded to the accident, did you admit to consuming alcohol?
Yes.
And based on that admission and your injuries from the accident, you were transported to the hospital.
Yes.
And while at the hospital, the police officers showed you a search warrant for the legal drawing of your blood to test for chemical substances.
Yes.
And for the purposes of this plea, do you have any reason to dispute the validity of that search warrant?
No.
And your blood was drawn to check for chemical substances, right?
Yes.
And to the best of your knowledge, was the result of that blood draw that you had a blood alcohol content of 0.187?
Yes.
And for the purposes of this plea, do you have any reason to dispute the validity of those blood draw results?
No.
Your Honor, I believe that satisfies the factual basis.
This is Delhi Township, since it was in Holt,
Yes.
Ingham County State. All right, I find that this matter is properly within the jurisdiction of the court, having occurred in Delhi Township, Ingham County, State of Michigan, on or about January 2nd, 2025. I further find that the defendant has knowingly, intelligently, and accurately provided the court with sufficient factual basis to find her guilty of the offense of operating with a high BAC and pursuant to the agreement reached with the prosecutor. The court will dismiss the original count of operating while intoxicated second offense. Mr. Noble, do you believe the court has complied with the court rules and taken the plea?
I do believe so, Judge.
Yes, before I forget. So, in order to participate in sobriety court, and that's what your goal is here, is that right? You have to sign a waiver and agreement, and I have a waiver and agreement that looks like it was signed by you and dated for July 29th. Is that your signature?
Yes.
So you do understand that you're giving up some of your rights in order to participate in sobriety court?
Yes.
All right, I will sign it so that you can participate in sobriety court. Estimate that was prepared, and it looked like it was prepared by one of our agencies. And Mr. Noble, have you had a chance to review the report dated July 23rd?
I have. Yeah, we reviewed that together at the last pretrial.
You believe the report is factually accurate?
I do, Your Honor.
Is that true, ma'am?
Yes.
Mr. Noble, if you'd like to be heard, I'm prepared to hear from you.
Thank you, Judge. As I indicated earlier, Ms. Crum does have a strong family support system in the area. She is the sole caretaker for her father. In addition, she has 2 minor children that reside with her and her mother. I believe Ms. Crum is a strong candidate for sobriety court. She was able to witness a hearing of sobriety court previous to this plea and sentencing. And when I spoke with her briefly prior to this hearing, she advised that she finds it to be helpful and believes that it will be very beneficial in helping her to achieve her ultimate goal, which is sobriety, not just for her, but for her parents and for her children. And she has the strong goal of getting better. And as this court is well aware, sobriety court is a terrific avenue for citizens in the area to achieve that goal, not just with this court's helpful oversight, but with a strong community to help build them up in the times of self-doubt or any times of insecurity, I suppose, to help motivate them to keep pushing, to keep fighting, to find that ultimate goal, because the alternative is much, much worse. And Ms. Crum is aware of that alternative, and she's aware of her decision on the night of January 2nd of this year could have gone a lot much worse for herself and for even the people in the home, which was the property that she did strike. Thankfully, nobody was injured or killed on that night, and that is not lost on Ms. Crum. And I don't want to sound repetitive, but I believe Ms. Crum will be a terrific candidate in sobriety court, and this court's oversight will be very beneficial for her.
Okay. What did you get?
What did I get out of sobriety court?
No, what did you hit with your car?
Oh, a house.
Hit the house?
Curtilage.
I was in a roundabout, parked in a roundabout, and the house was in the roundabout, and I came around and lost control and hit the house.
So I don't know if there's like going to be some damage that they might request from that. It's possible. They may have a deductible or something like that they have to pay for repairs to their property. So you could have to pay that as part of sentencing.
Okay.
Okay. So this is your opportunity to speak on your own behalf. You can tell me whatever it is that you think I should know about you before we do the sentencing.
I made a poor decision that morning. I put others and myself in danger.
Why? Why do you suppose you did it?
Not a clear mind.
Is that because of the alcohol, or is it because you had some other things that you were worried about?
The alcohol, and I was worried because my father was in the hospital at that time.
Is he okay?
Yes.
But at that time, there was some doubt about whether he was going to be okay.
Yes.
Is that why you were drinking?
Yes.
Well, drinking seldom helps to cure the ills of society. I mean, I understand that people do it because, you're trying to numb yourself to what's going on, but usually it presents its own set of complications by doing that. Witness that you're here now because of that. But this could actually be sort of a blessing in disguise because you had so much alcohol in your system, it's really kind of hard to get there unless you've got some sort of underlying problem. Do you kind of understand what I'm talking about?
Yes.
What do you think about what I'm talking about?
Drinking too much.
That the ability to drink that much means that you were probably drinking enough that your body felt acclimated enough to be able to do that and then walk out to your car to drive your car. So some people will get a lot of alcohol in their system and they're just no good. They can't get up off the floor. And you've had enough alcohol in your system that could have been true for you. Unless you've been building up to that point over time.
Yes.
You think you were building up to that point over time?
Yes.
Why do you think so? What was going on? Is it all still related to your dad, or is it just related to others?
Just stress in general. But yeah, I guess when I do drink, I just overdo it.
Well, that's certainly not the way to cope with life, because life is life. Life is going to life, and it's going to give you some curveballs. You can't drink them away. You know what I mean by that?
Mm-hmm.
That you can't basically make them go away by drinking. It usually makes the problem worse, because now you've got the issue of having consumed a bunch of alcohol and response to it, as opposed to working through whatever the problem is and trying to come up with a resolution for those problems. Why don't you have a job?
Because I'm taking care of my father right now, and when the kids were younger, I have 3, but one's 18 now. I was just sole provider. Like, their dad made enough that I didn't have to.
Is he still around?
No.
So everything basically rests on your shoulders, but you have the assistance of your mom.
Yes.
Does she still work, or is she
just retired?
Good for her. So, is there anything else that you think that I need to know as part of this process?
No.
So, you're going to be on probation with me for up to 2 years. And let me just go through this sheet with you, just to make sure that we don't miss anything. I'm not going to order any fines and costs for you. I'm going to find that you're indigent for those purposes. But if there's something that comes out of the accident, the housing situation, we could potentially have to pay that as part of your probation.
Okay.
I don't know what they might try to do, but certainly that is not a foregone conclusion that you could just walk away without having to pay anything. You may end up having to pay something. But I'm not going to order that you pay any fines and costs, okay?
Okay.
You're going to be with probation on a regular basis, depending on your phase requirement, and it'll be on a weekly basis going forward. You're not to possess, carry, use, or purchase a firearm, ammunition, or other dangerous weapon beyond a gun or a knife set, archery set, martial arts, weapons, tear gas, pepper spray, brass knuckles, a sword, a blackjack, anything like that.
No.
Not to violate any criminal law of any unit of government, not leave the state without the prior consent of the court. You're to make a truthful and accurate report to the probation officer at each contact. You're to notify probation within 24 hours of any change of address or employment or school status, and within 24 hours of any contact with the police. Even if the police force themselves on you, you have to go to the police station to see them for some reason. You have to report that to your probation officer by the next business day. It'll provide proof of healthcare coverage or meet with the healthcare navigator directed by probation. In addition, you to comply with and complete all phases of the special report program as a condition of successfully completing the program. You are also to not use, possess, consume, nor be in the presence of alcoholic beverages or controlled substances, nor be present in any place where alcohol is sold for consumption on the premises. Basically, you can't go to bars, bowling alleys, restaurants, and places where alcohol is served. And you similarly can't be around people that are using controlled substances. Even if it's marijuana, and I know the marijuana is largely accepted in the state of Michigan now. You can legally possess and use marijuana over the age of 21, but that would be a violation of probation to do that. Understood?
Yes.
Okay. So you're not to use or consume products containing alcohol, poppy seeds, or any other illicit substance. In addition, you're not to abuse prescription and non-prescription drugs, and provide verification of all prescriptions to your probation officer within 48 hours of obtaining the prescription. You're to attend AA as directed. That means that you'll attend on a daily basis. Well, basically, what I want to do is have you meet with your sponsor on a daily basis. You wouldn't go to an AA meeting every day, but you would want to have some contact with that community to make sure they're reinforcing your desire to stay away from alcohol. So sponsor within 60 days and daily sponsor contact is mandated. You are to attend and complete counseling as recommended in the substance abuse assessment. You're to drop for probation, law enforcement, testing agents, case manager, physician, or counselor. You are to submit 120 hours of community service by the end of probation. You're to have an 11 o'clock p.m. curfew. You're to keep all medical appointments, follow all medical advice, take all medications as prescribed, and sign a release. And you're to bring all medications to each probation appointment and counseling session and comply with any medication inventories. They want to do a pill count, for example. They could do that as part of your probation.
Okay.
So your license is subject to suspension. That'll be handled by Secretary of State and depend upon your master driving records maintained by Secretary of State. And if you're granted driving privileges under the interlock program, you have to comply with the terms and conditions of that program. You are to submit to fingerprinting by law enforcement as directed by probation. You are to submit to a search of your person, your home, or your car upon the request of either probation or law enforcement officers who have reasonable suspicion to ensure compliance with our probationary terms. So if they want to do something to make sure that you're not drinking and don't have anything in your car or something, they can actually do that. So you understand that?
Yes.
Okay. In addition, you're to attend our review hearings starting today. So you'll be on a schedule that'll have you see me every 2 weeks. And you're to attend the next graduation. I think the next graduation is not until December, but you'll go to the graduation, you get 4 hours of community service credit just for going to the graduation to see what goes on. Now, despite the fact that I've ordered all these things, you may be able to appeal. If you decide to appeal, you need to do so within 21 days. And if you require the services of an attorney and you couldn't afford to hire the attorney, then you need to let us know within 14 days so that I can refer you to an attorney that's going to be able to represent you without cost to you. So now you're on probation with me. Do you have any questions or concerns?
No.
Okay. Mr. Noble?
Nothing further, Judge.
All right, so that nice gentleman over there to your right is going to help you from this point going forward, okay?
Okay.
Let me just make a couple quick notes and I'll hand him the file. You take her downstairs, right?
Yes, sir.
All right. Here's her file. I don't know if Elaine needs to touch it to give it the blessing to make sure that all the papers are in here. I don't think I taken any of them out. Mr. Lerma, how are you? Were you holding on to see me or are you all done?
No, sir, just riding out with you.
I appreciate it. I need all the camaraderie that I can get.
No, I'm a big fan.
Yeah.
Here to the end. Thank you,
right.
sir.
Thank you, guys.
Thank you, Judge.
See you next time.
Thank you, Judge.
Okay. See you, Tyler. Okay, you have a good day, okay?
You as well. Thank you.
All right.
Hey, I got real quick. You got 2 seconds? I was thinking about this. You ever watch the YouTube channel?
Okay. Is English your first language or no?
English was my first language. Later, before was the my Bengali language.
Okay, would you feel more comfortable if you had an interpreter?
Yeah, interpreter will be better, but,
Okay, all right.
but I can understand what you're saying.
Are you understanding me?
Yeah,
Okay, you tell me if you don't understand me, right?
yeah.
Okay. This charge is a misdemeanor, carries a maximum penalty of up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
That much money?
Okay, that's the maximum penalty. That doesn't mean that that will be the penalty.
But I had a mental issue, that's why I did that.
Okay, so let me stop you there. I don't want you saying anything about the charges, okay, at this point. Okay. Let me ask you this. Since you understand me, would you like to have an attorney on these cases?
Yeah, I want an
Okay,
attorney.
Ms. Perroni, I'll appoint the PD. I'll give the short form version of the charges so that she understands, okay? So you're gonna have the public defender on all of your cases, okay?
Okay.
All right. Go ahead.
Assistant Public Defender Lauren Perroni on behalf of Ms. Roy.
The first charge is the malicious destruction of a building, 200 to 1,000, the 1 year offense. And on that one, you waive formal reading, your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea on that case. The next case, the 1298, is the charge of malicious destruction of a building less than 200. The 93-day offense that's alleged to have occurred on March 30th, 2025. On that one, you also waive formal reading, your client stands mute.
Yes, please, Your Honor.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea on that case. On the case ending in 1299, it is the charge of malicious destruction of a building less than 293 days offense alleged to have occurred on March 6, 2025. Waive formal reading, stand mute.
Yes, please, Your Honor.
And in every way, formal reading, standing mute, court will enter not guilty. And the last case ending in 1300 is two charges. The first count being malicious destruction of a building less than 200, the 93-day offense. And that's on April 5th, 2025. All of these occurred at Randolph Court Apartments. Count two is the charge of stalking, which is punishable by up to 1 year incarceration, $1,000 fine plus court costs, and 5 years probation. Waive formal reading, stand mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. All right. Let's deal with the last case.
Guilty. Thanks for results. We'll work it out, okay?
You'd like all of these adjourned?
Yes, please, Your Honor. She has another arraignment scheduled for the 17th. I do not remember the charge that is.
Before me?
Before you, yes. I think it's a retail fraud. So I guess.
Why don't we have?
I don't know. I don't know.
It looks like I see a malicious destruction of building.
Another one?
For an arraignment and retrial, as well as I see 2 additional cases, so 6 total. The other 2 are on the 17th. I charge 6 at the same time, Your Honor. So there are 6 total.
Okay, so that we don't have any confusion, I'm going to briefly pass the matter. Can you get those into me? Have them. I'm going to have them bring those down so we can get all of them together. Okay, so have a seat. We'll take us a minute. We'll get the files down and we'll continue on with this. Okay.
Thank you. Thank you, Judge.
Thank you.
Travel dates.
On a motion for intervention in lieu of conviction, so in a moment, you'll be asked to change your plea to guilty to 2 counts of the indictment The court accepts your plea but does not make a finding of guilt. Instead, I'll hold your plea in abeyance or set it aside and require you to complete a plan of intervention, which if you successfully complete that plan of intervention, then the prosecution of this case ends with no finding of guilt, and I will dismiss these charges against you, okay?
Yes, sir.
The other side of that is if you fail to complete the plan of intervention, if you break the law again or you use illegal drugs, the court will be able to make a finding of guilty that's based on your plea today, and then I will sentence you on these charges. Do you understand that part of it?
Yes, sir.
How old are you?
31.
How far did you go in school?
High school.
You can read and write?
Yes.
Are you a citizen of the United States?
Yes, Your Honor.
Has anyone promised you how the court would sentence you if you failed to complete ILC?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, Your Honor.
Are you satisfied with the representation you've received from Mr. Perry?
Yes, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Do you take medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document. This is called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, Your Honor.
Did you read this and go over it with your attorney before you signed it?
Yes, Your Honor.
And you believe you understand what it says?
Yes, Your Honor.
This document says you're entering a plea of guilty to theft as a felony of the 5th degree that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. The second count is one of theft as a misdemeanor of the 1st degree that carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Do you understand the maximum penalties?
Yes, Your Honor.
You are also subject to a discretionary period of post-release control on the felony charge, which means if you are sent to prison on that charge upon your release, the adult parole authority may choose to supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
It's not, excuse me, it's not mandatory that you're sent to prison at all. Even if you fail to complete ILC, the court still has discretion to place you into community control. If you, under community control, you'll have rules you must follow as well. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, Your Honor.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you. And I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, Your Honor.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. You understand that?
Yes, Your Honor.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, Your Honor.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, Your Honor.
Do you believe you understand each of these rights we've gone over?
Yes, Your Honor.
Do you understand that when you enter a plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes, Your Honor.
This is how you wish to proceed.
Yes, Your Honor.
Ms. Tranter?
Your Honor, in addition to the facts alleged in the indictment, this happened on April the 26th of 2025. Warren County, State of Ohio, the defendant was at Miami Valley Gaming, picked up a wallet that had been accidentally left behind by the victim in this matter. Wallet contained several credit cards, his driver's license, and $850 in cash.
Mr. Perry, anything on those facts?
Nothing, Judge.
Mr. Landers, did you hear the statement that she read?
Yes, Your Honor.
Do you admit and acknowledge what she said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up, entering a plea of guilty, the rights we covered.
Yes, Your Honor.
What's your plea?
Guilty.
Court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed, and I will accept your plea of guilty. I'm going to grant your motion for intervention in lieu of conviction and order these proceedings stayed pending the completion of the terms of that supervision. So you will be on ILC for a period of 3 years and subject to the supervision of the Warren County Probation Department. I recognize you've already engaged in treatment, so I'm simply going to order you to continue with that treatment to its completion. Do you understand that?
Yes, Your Honor.
There is restitution owed in the sum of $1,000 to Charles Soto. Ms. Tranter, is there anything else?
No, Your Honor, thank you.
Mr. Perry?
Nothing for the judge.
Officer Bridgman, is there anything else?
Nothing else.
Okay, Mr. Landers, good luck to you. Officer Bridgman is going to want to meet with you for just a little bit while after court. So if you'll head back down to court services where you checked in earlier, she's going to meet with you today, okay?
Yes, sir.
All right, good luck.
Thank you, Judge.
See ya.
Go ahead.
Court calls the case People versus Lenata Rue Warford.
Ashley Phillips for the people. This is a show cause for failure to appear before an arraignment.
Rue Warford. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. I'll give it 10% privilege. That warrant will issue immediately. Court calls case People versus Sergio Sanchez.
Ashley Phillips for the people.
Good morning. What's your name?
Sergio Torres Sanchez.
All right. Sir, this is an arraignment.
Yes.
You are before the court on the charge of no insurance under the operating motor vehicle without insurance under the motor vehicle code. Do you understand that charge?
Yes, Your Honor.
That is alleged to have occurred on or about August 2nd of this year. All right.
Yeah.
That's a misdemeanor punishable by a fine between.
A hearing on the issue of restitution. Does that work for everybody?
Yes, Your Honor.
All right. Mr. Harris, anything on behalf of the state?
Yes, Your Honor. In review of the PSI, I noted he has 4 days of jail time credit. There is a substantial amount of restitution that we're requesting, which we are going to proceed with a hearing today. Your Honor, in review of the criminal history of the defendant, I noted that he has numerous contacts. He has been convicted of theft offenses before and appeared he had been sentenced to prison before in the past as well. This was the Dorothy Lane Market in Mason. It was a large project. Zach Phillips is the owner of Simcoe, who was a supplier and putting in the refrigeration lines in the building over a course of period of time. They noticed this copper piping was missing. They took efforts to locate that. There were air tags that were put in, tools, and they went hands-on trying to find some of these missing tools in the copper, which led them to the defendant. As I said, this is a substantial amount of restitution based on the purposes and principles of sentencing and risk of recidivism. I think some punishment is in order, as well as the restitution, which we are seeking in excess of $32,000. I know that we're going to get to that after this, but I think that some punishment is in order.
All right, we have a representative of the victim who is present, right?
He is present.
Anything you want to tell me about sentencing, sir?
It was a large theft. It wasn't anything small. It was over multiple days. So it was pre-planned on multiple occasions and with no real care of anybody he was affecting.
So are you guys out this money, or did insurance pay for it, or where are we at on that part of it?
I had to buy it as a company. Again.
Okay, so the company is out the money, right?
Correct.
Okay. Is the way I'm sorry, what was your name again?
Zachary.
And your last name?
Phillips.
Okay. So, Mr. Phillips, the way I look at these cases is, we have two competing interests here. Number one, Mr. Wilcox ought to be punished for the things that he did. Number two, you want your money back. And it's kind of easy for Mr. Harris to stand up and say we should do both. But in my world, my experience is I can't do both. I can either punish him or I can work to get your money back. And the way I look at this is I favor getting you your money back. And so that's why we work with folks on probation. I assume that's your position, but I will tell you, it doesn't cease to amaze me sometimes when people come in here and say, I don't want my money. I just want to see him go to jail. And if that's where you're at, that sort of changes the equation a little bit.
Ultimately, I want to see my money, but I don't think if he just gets probation, I don't think it's going to change his position on what he's going to do next, how he's going to get the money again. Is he just going to steal from somebody else to get me my money? Yes, I would love to have the money today, but if it takes 10 years, it takes 10 years.
Okay, thank you, Mr. Phillips. Officer Wilford, anything from probation?
Nothing further, Your Honor.
Mr. Cello?
Yes, Your Honor. I think the state has glossed over some significant portions of the facts. Mr. Wilcox pled to theft because he had taken tools specifically that did not belong to him, and had those in his vehicle when his vehicle was searched by, I believe it was Officer Seacrest. He pled to theft because he had those in there. There was an air tag, as let's call it Mr. P. Mr. Harris had mentioned previously. The air tag is what traced the police to Mr. Wilcox's residence. That aside, the substantial amount of restitution is sort of a different theft, if you will, but encompassed under the same singular charge. Mr. Wilcox stands adamant that, again, will come out in the restitution hearing, that he had no part in the taking of these copper pipes that are alleged. Certainly, he'll take responsibility for what he did, and he's entered a plea to theft, but that Mr. Wilcox's mind is related to the items found, the tools found in his vehicle. So we'd ask the court to place him on a period of probation. Yes, he has many, as Mr. Harris points out, many contacts with the court, but he doesn't have a ton of convictions, and there's a distinction there. Yes, he's been in the Department of Corrections, and I'm not downplaying that either, but there's a distinction between the number of contacts versus the number of convictions. So in any event, I'd ask the court to place him on a period of probation. And as you previously remarked, I understand that you're trying to work to get Mr. Phillips and his company the money returned to them, but there's still a burden by the state for them to demonstrate to the court that it's Mr. Wilcox that bears the responsibility of that. So I'd ask the court to reserve judgment until the end of that hearing. Thank you.
So I'm confused as to where we are, and maybe this is all my fault. I thought that Mr. Wilcox was pleading guilty to the theft of the property, and there was an issue about how much that property was worth.
No, he pled guilty to theft, and the theft was of the power tools that were located in his vehicle, and we concede and allocate that those items exceed $1,000, which is the statutory requirement for a felony 5 theft. But in addition to that, the state has sort of, under an umbrella of one charge of theft, encompassed these pipes as well. And I think that the court should reserve judgment as to whether or not Mr. Wilcox bears responsibility for repayment of the cost of these pipes until this restitution hearing concludes.
But he's saying he didn't take the pipes, right?
That's correct. Yes.
Your Honor, there's evidence that he was scrapping pipes on at least 2 occasions at a salvage yard, and this was in the Cincinnati area. There's videotape of that as well. So that is part of the discovery. There was also copper found in the vehicle as well, scrap copper on the floorboard when the vehicle was searched.
So is that the evidence that I'm going to hear today as to whether or not he took these things?
I was under the impression, I don't think that there was a question of him taking copper. It was a question of how much.
Nope. It's always been a question of whether he took copper. There was copper found in his vehicle, and we'll even stipulate to that fact. But he was working for Innovative Labor and Cleaning Services. He worked at multiple job sites during multiple weeks, during multiple months, cleaning up job sites. He would find scrap and go scrap garbage, which included copper. So, I mean, yeah, there's going to be evidence multiple times of him at this recycling center. Absolutely. And we'll stipulate to that. He works at the time, he was working in a cleaning service. They go to job sites like Dorothy Lane Market and other various commercial industrial job sites and clean them up.
Your Honor, also there's evidence Mr. Phillips followed him on the final occasion where he scrapped copper and did identify the copper as his. It had the fittings on it that same day where they located his vehicle and did a search warrant of the vehicle. So Mr. Phillips traced some of that copper right to the defendant.
Scraps traced.
I don't think it was even considered scrap because it had the fittings.
Oh, okay. This is, I take the responsibility for this. This is my fault. I guess I did not understand the nature of what we were doing here in this restitution. I thought that it was an issue where he took the copper and then there was some dispute as to what was taken. So I think probably what makes the most sense is for Mr. Wilcox to withdraw his plea and we set this for trial. So then we can have a determination as to what he took. And again, that's my fault. If I push this ahead at the plea.
My understanding of it was he wasn't disputing that he took copper. It was how much copper and how much it was worth.
Well, Mr. Ocello seems very adamant that he did take copper or that he did not take copper, right?
Oh, he had copper scraps in his car. We're not even, I just offered to the court and to the state, we would stipulate that he had copper in his car. And it may have even been from this job site, but it was scraps that he had cleaned and was taking to the scrap yard as scrap to acquire money. It's not $32,000 worth, and it's not 11,500 pounds worth of copper that Mr. Wilcox took from this location.
Okay. Again, this is my mistake. I did not realize that this was the nature of the dispute. So I think probably what makes the most sense is for us to set this case for a trial. I don't know that we ever got that far, Mr. Ocello.
I'm sorry, I didn't catch
I don't know that we ever got far enough to, we had this set for a jury in May.
We had a trial set on August 18th and 19th, I believe.
All right. Are we bringing in a jury for this? Do you need to talk to Mr. Wilcox about that?
Could I have a few moments?
Okay, why don't you do that?
Please.
Let's go ahead and break for a little bit and figure out what we are doing. Mr. Phillips, this is on me, so I apologize to you for this confusion. And let's take a couple of minutes, take a break, and see where we're at.
$200 to $500 and up to 1 year jail. Understand that, sir?
Yes, Your Honor.
All right. First question I have for you is, you want to be represented by an attorney?
Yes.
It's a public defender case.
Since the public defender Lauren Perny on behalf of Mr. Sanchez, we waive formal reading and stand mute to the charges, please.
Defendant and wait formal reading standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned September 17th, 2025, 9 a.m. Set bond in this case in the amount of $5,000. Personal recognizance, standard conditions, including no assaultive behavior or possession of any weapons. No possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that? Sure. All right. Very good.
Thank you.
Court calls the case People versus Corey Sellers.
People. This is a show caution.
Corey Sellers. No response. Bench warrant will issue for defendant's failure to appear. Bond in this case will be set in the amount of $5,000. Give a 10% privilege on that. Warrant will issue immediately. Court calls case People versus Giselle Safer.
Ashley Feltus for the people. Good afternoon. This is public defender Lauren Perny on behalf of Ms. Seifert. State your name for the record, please.
Giselle Seifert.
Your Honor, we are asking to set this for final settlement, please.
Jury final settlement conference will be set for October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30 a.m. Both of those proceedings are in person. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you. Thank you. Court calls the case People versus Stevens. Shimoon.
Ashley Feltus for the people.
Hello, Your Honor.
Hello, what's your name, sir?
Stephen Shimoon.
All right, sir.
Yes, Your Honor.
You are before the court on the charge. What are the maximum penalties on this case? Furnishing to a minor.
Furnishing alcohol to a minor.
Tobacco.
Yeah. Furnishing to minors is 722-6411, Your Honor.
641 is what I have. But
$100 fine.
the $100. Okay.
That's a,
Sir, you are before the court on a misdemeanor complaint that alleges that on August 19, 2025, Willis Road, that being near Willis Market in Augusta Township, that you did furnish tobacco to a minor. Do you understand the nature of that charge, sir?
Yes, I do, and I'm sorry.
That is hold on. That's a misdemeanor, punishable by up to $100 fine. You understand that?
Yes, I plead guilty, sir.
You want to plead guilty?
Yeah, I'll pay my fine. I messed up, and I deserve to pay my fine.
It's a misdemeanor. I need you to raise your right hand to be sworn.
Yes, Your Honor.
Do you understand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do, Your Honor.
Family, so I don't know if you can convey that differently, because evidently I have met a wall.
Mr. Wilcox, where are we at in this?
Well, Your Honor, where we're at in this is they got one charge of theft on me, and then they're trying to combine different days and saying that I took a whole bunch of scrap in different days, and I only have one felony theft. If I would have went in there a bunch of different days, you would have to have a bunch of different thefts for different days. You can't add them all together. This is what I'm failing to realize. I admitted to my guilt, Your Honor. I took scrap copper out of there. The scrap was in bins. The guys probably wanted to scrap it themselves.
the detective had a receipt of $1,200 of what I got off of that scrap. I don't know where the $32,000 coming from, but I'm admitting that I took scrap out of there and there was tools found in my car. So I don't want to go to trial with something I already admitted in open court. I made a mistake. I took scrap copper and I took some tools, but $32,000, like he said, 11,000 pounds without a big tractor trailer or a group of men, there's no way I would have took all that scrap in one day, which is we're on about the day of that this happened, and then and I took it, and it's just impossible to take 11,000 pounds worth of scrap in one man with a Ford Flex SUV, sir. That's what I'm saying. I'm admitting that I took some scrap copper right there. When I go on construction sites, they let us have scrap copper. They give it to us. Y'all go ahead and take it and clean it up, get it off the ground. It's the part that when they're putting a pipe in the wall and they cut it, and then the scrap that's left over that don't fit on nothing, and it just accumulates after a while. That's what I'm admitting to, sir. I'm not trying to take this to trial. I'm admitting that I took scrap copper and that I took some tools out of there that the people got back. But this 32,000 is over exaggerated. And even in my discovery, there's evidence that they had somebody from the site that took other things off the site, some Mexican related guys or whatever. It says it in my discovery that there was other people that took things off of the site. And so I don't know if it was the Mexicans that took a bunch of extra scrap and then they're trying to put it all on me, but it's just like everything is just getting on me. When in the discovery, it says in black and white that there was other things taken off of that site from other people and they was caught red-handed with it. So I don't know if they're like some other guys might have took $20,000 worth of scrap, some guys that had a group of people in a big truck, but I didn't put $32,000 in the Ford Flex. I'm admitting to, and that's what I thought the restitution hearing was after the sentencing. I didn't think that it was going to be before the sentencing. I'm thinking I did admit and I signed the paper for the plea deal, but I'm thinking we were going to talk about the proof of what I took after the sentencing. That was my impression. I mean, maybe I'm wrong about it.
There's enough confusion to go around today, Mr. Wilcox, so I don't really fault you for that. So here's where we're at, okay? So you are accused of taking not scrap, but metal that was for use in the project, right? Am I right about that, Mr. Harris? So the accusation, the allegation against you is that you took materials that were going to go into the project and that the value of those materials is far in excess about what you're talking about. Now, if you say I didn't take that stuff or somebody else took that stuff, then that is a dispute that needs to be resolved. And the way we resolve a dispute in this room is we have a trial. Now, trial means different things to different people. Some people think we have to have a trial. That means that we have to bring in a jury, and that we have to do all of that. That may or may not be the case. That's up to you. But my vision for this case, I think, would be if I had my way, which sometimes I get, sometimes I don't. It seems like we should set this for trial, that you should waive your right to have a jury decide this case, and that Mr. Harris should put on evidence about what was taken and about who took it. And you let Mr. Acello challenge that evidence. And if in fact I find that you did take that, then you're going to have to pay it back. If I find out that the state has not proven that you're able to do that, then you don't have to pay it back. We sort of understand, though, that you're not going to walk out a free person in terms of not being convicted of this, because you at least admit that you took some of it, but not all of it. And that lets Mr. Acello do his job for you. That lets Mr. Harris do his job. And Mr. Phillips would then testify to see if they can prove this to me. Because if they can't, then you're not responsible for the things that they can't prove that you didn't take. So my problem is, Mr. Wilcox, if I have somebody who says, I'm taking responsibility for the things that I did and I'm pleading guilty, when in fact you are not taking responsibility for all the things that you were accused of. Sometimes we do that. We lower charges, we dismiss charges, we make accommodations like that for the plea bargaining process. We do that every day, but it doesn't seem like this case is a right fit for this. Now, you have the absolute right, as Mr. Accello will tell you, you have the absolute right to bring a jury of 12 people in to decide this case. If you want to have a jury decide that, that's fine. It doesn't matter to me. But like I said, I don't want to get into a situation where I have a restitution hearing and I find that the copper is worth this, and you say, well, I didn't even take that. That's a problem. That's a problem for you. It's a problem for me. And it's going to become a problem for Officer Williford because she doesn't want to supervise somebody on probation that thinks that they didn't really do that. So that's how I think this case should go forward. I am not going to go forward with a sentencing and a restitution hearing today with you telling me you did not do the things that you pled guilty to. I'm just not going to allow that to happen. So I'm going to set this case for trial. If you want to bring a jury in for that, that's fine. Talk to Mr. Accello and let me know that. If we don't want to do that, seems like we should reboot this for another half day, kind of like we're here today for, but not really. And I hear the evidence and I sort all of this stuff out.
Well, excuse me, sir, allow me to speak. That's what my understanding and what he described to me was the restitution hearing was going to be after the sentencing of how much they can prove or whatever they felt like I took. That's what I'm saying, sir. I don't know what 32,000 even looked like of copper. That's what I'm saying.
That's why we have a trial, Mr. Wilcox, so that we answer all of these questions with people under oath and they're testifying and they say, this is what happens, because Mr. Harris is saying that Mr. Phillips is going to say that he has more evidence than this that I haven't heard, that you maybe don't know about. And we just
Not in my bill of particulars. That's not in my bill of particulars. More evidence is not in here.
No, not evidence. Evidence is what the people testify to at the trial. So in your discovery packet, you know that a person is going to testify in the case. You don't necessarily know the specifics of what they're going to testify to. That's why we have a trial. Does that all make sense to you?
Yes, it makes sense, but it's something that I'm not willing. I'm not trying and don't want to do is to take this to trial. Like I said, under the fact that I already stated in open court that I took things. So I don't see me beating a case where I've already admitted and I don't see where I'm going to get a not guilty verdict from things that I already admitted and already signed off on. I just don't see no win. There's no win in that. What they're going to say, oh, you're not guilty of this F4 and then we're going to drop it, but you're guilty of this. I mean, what I'm saying is, I wanted to take this plea deal. I don't know where all this, I didn't take this and they take that from. I wanted to pay these people off. I've been working. The probation knows this. I've been a working guy, construction for 4 or 5 years.
Mr. Wilcox, I'm going to interrupt you right there because that is an issue that is not at all relevant to your guilt or your innocence, okay? You are accused of, let's just keep it simple. You're accused of taking a pack of gum and $10, okay?
Yes, sir.
You're saying I took the pack of gum, but I didn't pay the $10. Mr. Harris is saying he took the pack of gum and the $10. We want our $10 back. And you're saying I'll pay you back for the pack of gum, but not the $10. That's sort of the way that we're at in this case. I'm saying I want to have a trial to determine whether or not you also took the $10 in addition to the pack of gum that you're admitting to.
Well, that's what I was under the impression that the restitution was for, to figure out.
It is not. And I was also under that impression, but that is not the purpose of the restitution hearing. Again, I take responsibility for that.
So can you please explain the restitution hearing? What were we going to accomplish with that?
A restitution hearing, for example, if you took a truckload of copper and you took that and got $20 for it, and Mr. Phillips says that copper is worth to me $10,000. I don't know what it's worth, but let's just say that's the number. they're entitled to the restitution for the fair market value of what you took from them, not what you scrapped it for where you took it. So if it's not scrap, if it's going into the project and it's worth much more money than what you say that you scrapped it for, that's a big difference. Does that explain that? Do you understand that?
And yes, and that's probably where we're getting this disconnect. That explains it. And I will never know, like you said, the scrap is going to be, of course, lower than the value that he probably bought it for or whatever he had to pay for it. And I won't know that price. But I was just going off of, with my lawyer, off of the scrapping price. So it was a miscommunication. I was thinking that they were saying I got $32,000 from the scrap yard. That's what I was thinking that they were saying. So that's where probably the disconnect comes from. I'm thinking that they're saying he got $32,000 from a scrap yard. And like if you take somebody's jewelry and you get half of the price for it, I understand that concept. But my understanding was I was thinking that they were saying I got $32,000 from a scrap yard. And that's where the disconnect is coming from. I'm admitting to my guilt, sir. I'm willing to pay these people back and move on with my life. I'm a working taxpaying citizen, and I have been. Like I said, I worked on numerous sites, and I didn't understand. I mean, these people, most construction sites give you copper and give you scrap and take these metals and get them off our site, please. They ask us to do it. So, I mean, this is the first time I've ever been charged for anything related to me working on a construction site. But I was under the impression that they were saying that I got $32,000 in cash when the detective showed me a receipt for $1,200. So that's where it is disconnect, sir. I mean, I already signed my papers. I'm admitting guilt. I'm ready to pay it off, like you said, how long it takes, I'll pay it off. I use my income tax money, whatever I have to do, pay it off. I mean, I just don't want to keep playing with the courts and all this stuff over something that I'm already admitted to, and I understand my guilt, sir. But like I said, I was in the wrong. The guy's got the tools back, the scrap, he's out of it, and he wants his money for it. I mean, if he says it's $32,000, and then you still had a restitution and he can show you that's $32,000 I took, I mean, I guess, like I said, sir, I don't want to take this to trial. I was never really trying to take this to trial. This is a burden on me. This case has been going on for over a year for some scrap metals. I never thought it would even go this far. Like I'm just, it's mind-boggling. Like it's just, I made a mistake, but I'm not out just robbing people and breaking in houses. I'm on work. And I didn't been, like I said, I've been to the scrapyard hundreds of times. You can go pull back footage from 2023, 22 of me scrapping. I can go get the footage and have people print it up. I've been scrapping copper. Most construction workers scrap copper, or they get pipes or whatever. Sometimes they have pipes laying there that they didn't overbought too much pipes, so they just and then overstock, and then you scrap those. So what I'm saying is, sir, I'm admitting to my guilt on this, but taking it to trial and then risking getting I just don't want to take the risk, sir. I mean, I know I made a mistake and I already signed for it, is what I'm trying to say. But I was under the impression they were saying that I got $32,000 from River Metals, the scrapyard. And that's why I was like, this was throwing me off. Because first he was telling me they were saying $50,000. Then it went to $40,000. Then they came up with this invoice and it went to $32,000. When I first was arrested and it's on body cam and the detective did an interrogation of me, he said that there was $50,000 stolen. And now today we're saying it's $32,000. So all this, it's like the numbers was jumping and going up and down. It was confusing me, sir. I didn't know what was going on. This detective told me it was $50,000 at first.
All right. Mr. Wilcox, I think I understand your position in this. And I still think we ought to set this case for a trial. And Ms. Frichello, you need to talk to Mr. Wilcox to figure out what our next step is.
I have a jury waiver here, Your Honor. I'm not sure if he wants to have a jury or if he wants to have a trial to you. I will inquire.
And Mr. Wilcox, you said something about the risk to you, okay? And in terms of the risk to you is right now, as we sit here, you're taking responsibility for some of this, but not all of this.
No, I'm taking responsibility
And
for
Mr.
all of it.
Wilcox, don't
I'm sorry, sir.
dare interrupt me in my courtroom. You're taking responsibility for some of this, but not all of this. And based upon your representations to me, you might be right about that. You might be right that there was some pipe laying there and that you didn't know that it shouldn't have been taken and you took it. That might be the case, but it also might not be the case. And Mr. Harris and Mr. Phillips, they're entitled to present their part of this case to me. And it makes sense for us to have a trial, not to bring in a jury, but that's your call, not mine, to have a trial. If we have a trial, I will determine what was taken, how much it was worth, and whether or not you took it. And if I find that you did take it and that it's worth X number of dollars, at the end of the day, I'm going to do the same thing to you that I'm going to do today that I would do after that trial. So when you say risk to me, well, you know, I'm not going to punish you for taking your case to trial. It doesn't work that way. However, it might be that at this trial, I get the sense that you are not being entirely honest with me, or you are playing games, that you're not accepting responsibility for the things that you do, in which case I will look at this case a little bit differently. But what I told Mr. Phillips at the beginning of this hearing still applies, is that I want to get him his restitution. And if I find it to be $30,000 in restitution, that's $500 a month over the course of the next 5 years. That's a lot of money. And you're going to have to pay that, or you're going to be incarcerated. That's how that's going to work. And I don't want to be 2 years from now and you're paying a couple $100 here, a couple $100 there. And then I'm going to basically look at you and say, you know, Mr. Wilcox, I think that you're not ever going to pay this off. Time for you to go to jail. And you're going to look at me and say, well, I didn't take this in the first place, so I don't even know why I'm here. So we need to figure out all of these questions. And the only way to do that is for people to sit up here under oath and testify in front of me and present their evidence so that I can decide what evidence I believe and what evidence I don't believe. Do you understand all of that?
Sir, I understand it. And like I said, I was taking full accountability. I just had the reasoning of I thought that they said I had got 32,000 from River Metals. That was the disconnect. They never say. That's why I was trying to figure out, like, why did they thinking I got 32,000 from River Metals? If he's saying that I got $12,000, a $1,200 receipt, and there's equivalent.
Mr. Wilcox, we're not going into this again.
Okay, sir. That's why I was trying to let you know. I took full accountability for what I was. I mean, it's.
But this theft supposedly happened over a number of weeks, right? And you're saying it just happened over one day. That is a disconnect. That's a question that I need to have answered.
That's what I'm charged with. I'm not charged. You gonna charge me one theft, and then you're saying he did it 16 times, but we're only going to charge him one time. You would have 16 thefts. That's the law, sir. I mean, that's what I'm charged with, one theft. I'm going off on the day of, or on this day, or about this day. I'm going off of that day. What's on my paperwork, sir? That's what I'm charged with. I'm not going off of any other day.
The indictment does say November 1st, 2024, not from this day to this day. Again, another question that I don't have an answer to. So, Mr. Cello, you need to take a minute, talk to Mr. Wilcox. Let me know if we're bringing in a jury for this.
Jury trial.
Your Honor, Mr. Wilcox has requested a jury setting.
All right, go see Ms. Otto, get a date.
I will do so immediately.
Not sure if there's going to be any time issues. I guess we have to recalculate, or if there'll be a time waiver, may settle that issue.
Why don't you go get a date from Ms. Idle right now?
Okay.
And then, I mean, he's out. Our try-by date shouldn't be that soon. But why don't you go ahead and calculate a new try-by date, go see Ms. Idle, make sure that the try-by date is within, and if not, we'll go back on the record.
I'm going to wait for him to calculate a date.
Well, you guys can both go back and see Ms. Idle together. She'll be expecting you.
So.
Stephen Shamoon.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of furnishing tobacco to a minor. That is a misdemeanor punishable by up to $100 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you still wish to plead guilty knowing that?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of August 19, 2025, at the location of 10079 Willis Road in Augusta Township, Washtenaw County, State of Michigan, what happened that makes you think that you're guilty?
I sold a vape to a minor after I checked the ID. I looked at the wrong date and it was my mistake. The officer was right behind her. He came in and he showed me that the long licenses are everybody's over 21. It was kind of tricky. It was a different license. I was kind of confused, but I've done my research and this will never happen again.
Okay, so you're given the ID and you looked at the wrong date?
Yes, sir. I looked at the issue date instead of the date of birth.
Okay. And the reason you did that is because it was a long life?
Yes, it wasn't the wide way. It was up and down. It was vertical. And the officers told me that anytime I see a vertical license, they're automatically under 21. So I know that now. I didn't know that before. But
gotcha.
My father's owned the store for 40 years, and I've been selling alcohol and tobacco for 25 years, and I've never, ever done this in my life, sir. I pride on checking ID.
I got you. And so you sold it. It was just something you hadn't seen before.
I'm sorry?
It's just something you hadn't seen before.
Yes, exactly, sir.
Okay, I got you. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Court will accept the defendant's plea of guilty to this charge. Sir, anything you want to say to me before I impose sentence?
Yes. Whatever fine you give me, I broke my leg. That's why I was supposed to be there in person. I'm doing this by Zoom. I have to come before you on the 9th for another case. Can I pay it on the 9th when I come in, or do I have to pay this today, the fine?
I'm going to make you hobble all the way down here to pay me.
Okay.
No,
I'm the victim in the other case. It's not a criminal case, just so you know.
You've been here once today.
Yeah, he physically came in at 9 a.m. today.
You came in at 9 a.m.?
Yes, and then they told me that I wouldn't see you till noon, so I asked them if they could let me come a little bit earlier, and they said that they couldn't do that, but they did say that I could use Zoom, which I really appreciated.
How'd you break your leg?
Flying a kid around my store like Superman.
What?
I was flying a kid around my store like Superman. He likes to be carried around like Buzz Lightyear. And I tripped over my own feet. And instead of trying to let the kid fall, I braced my fall by picking him up. And I took the grunt of the fall. And I broke my fibula, or my tibula, my shin.
Then showed up here at court early. Had to go home. He's just bad luck. I don't want him here.
I'm telling
No.
You're going to see me on the 9th. I have to come. I'm a victim in another one of your
quit threatening
cases.
me. No. All right. Oh, my goodness. And do I have to keep reading it?
Oh, the money?
Yeah.
Give me a minute.
All right. I'm gonna do something, sir, so just hang on a minute and then I'll come back and sentence you. So just sit tight for a minute.
No problem, Your Honor. Thank you.
Not like you can go anywhere. You only got
I'm stuck on
Anyway.
the couch. You
I'm
see my
sorry.
crutches?
I just had to say it.
I'm stuck.
Court calls the case for the people versus Matthew. Is it Shimshed Demini?
Shemshadini?
This is about the defender Daily on behalf of Mr. Matthew Shemshadini, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Matthew Shemshadini?
Thank you, Your Honor. I have had the opportunity to review the discovery in this case and go over it with my client. We are asking that this case be set for final settlement conference.
Jury final settlement conference will be set October 17, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30. Both of those proceedings are in person. Bond continued.
Thank you, Your Honor. Yeah.
Thank you.
Because it's kind of.
Seriously?
Yeah.
All right, never mind. Okay. All right, thank you.
Thank you.
Mr. Shimon, in terms of sentencing in this case,
Yes, Your Honor.
fines and costs of $125, that's as low as I can go on it. You can pay that on the 9th.
Thank you. I'll be there at 9 a.m.
He said at 9 a.m. I don't want him walking around here.
All the prelims that day are at 9 a.m., but I don't know.
Oh, it's a prelim?
He said the 9th, so I assume.
Oh, it's a prelim.
So.
Okay, got it. All right, so it is at 9. So pay that by September 9, 2025.
No problem. I'll pay that as
All
soon as
right,
I
sir.
get there.
Okay, thank you, sir.
Thank you, Mr. Simpson. Have a wonderful rest of your day.
You do the same.
Bye-bye.
So that should teach you not like kids around like Superman or Buzz Lightyear.
Yeah, don't do it. Don't do it.
I thought he was gone, but just don't do it.
You asked for 2 additional cases.
Oh, they're here.
Yeah, whenever.
Court does call the case of people versus, is it Marta Gia Stewart?
Ash Fellows people.
I'm sorry.
It's not different. And it's arraignment pretrial.
I'll issue an order to show cause. The defendant's failure to appear. Court calls case of the people versus Brandy Smith.
Fellows people, show cause for getting.
Brandy Smith. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege. That warrant will issue immediately. Court calls case of the people versus Leo Stringa.
Public defender Natalie Stringa, Your Honor, who is not present. He is currently hospitalized. I did send the court as well as the people yesterday the letter I received Michigan medicine for his hospitalization. And I would work.
Will 2 weeks be enough, or do you want the October date?
Candidly, I don't know. He was texting this morning. He's still in the hospital.
October 15th, 2025, 9 a.m.
Thank you.
Court calls case People versus Jaden Thompson.
National Justice for the People.
Oh. Hello. What's your name?
Jaden Thompson.
All right. So arraignment pretrial. Ma'am, you are before the court on a misdemeanor complaint that alleges between the date of February 23rd, 2025 and April 1st of 2025 at the location of 5450 Carpenter Road, that being Sam's Club, that you did commit the offense of embezzlement by an agent or trustee more than 200, but less than 1,000. You understand that charge?
Yeah.
Okay, that's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property, which is was embezzled. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes.
Okay, first question I have for you. Do you want to be represented by an attorney?
Yes.
Public defender, please.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Thompson, we would waive any further reading of the complaint, stand mute, and ask for an adjourned pretrial date, please.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. We'll adjourn the pretrial in this case to September 17th, 2025, 9 a.m. We'll set the defendant's bond at a $5,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of weapons. You understand that, ma'am?
Yes.
Also, there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes.
I'm going to also indicate that you're not to enter any Sam's Club in the state of Michigan. You understand that?
Yes.
That does it.
Thank you, Your Honor.
Court does call the case of the People versus George Walker.
National Justice for the People.
Hello, Your Honor.
Hello, what's your name?
George Walker.
Sir, you are before the court on a misdemeanor complaint that alleges that on or about June 13th, 2025, location of Carpenter Road near Washington, that you did in operating a motor vehicle failed to stop after a collision. You understand that charge, sir?
Yes, sir.
That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes, sir.
First question I have for you, you want to be represented by an attorney?
Yes, sir.
This is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Walker, we would waive any further reading of the complaint. My client stands mute, and we would also ask for an adjourned pretrial date, please, Your Honor.
And then having waived formal reading, standing mute, court will enter a not guilty plea. On defendant, bless you, on defendant's behalf. I'll set his bond at a personal recognizance, a $5,000 personal recognizance, although the standard conditions, no assaultive behavior, possession of any weapons. I'm also going to indicate no alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, sir.
I'll adjourn his pretrial in this matter, September 17th, 2025, 9 a.m. Bond continued. Or bond. Yes.
Thank you, Your Honor.
Court calls case People versus Reginald Williams.
National Justice for the People.
Reginald Williams. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000, 10%. Warrant will issue immediately. Court calls case of People versus Keontae Wright.
National Justice for the People.
Public Defender Natalie Pate on behalf of Mr. Wright, who I believe should be present via Zoom.
Deontay, right? Okay.
I'm here.
Okay, state your name.
Keontae Wright.
All right, what are we doing?
Thank you, Your Honor. I'm a adjournment. I need to have a discussion with my client. Was able to leave a voicemail. They did contact our office this morning. So
September 17, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls case People versus Mohammed Yatsei.
I should call this for the people. This is a show cause for failing to appear.
Yatsei. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set $5,000 with a 10% privilege on that. That will issue immediately. Got it. This is all I got. We can set up that next block.
Yes.
All right. Court recalls the cases of the People versus Bernardi Roy.
I should call this for the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Roy on the already arraigned files.
I now have the other two files. Case ending in 1239 is the offense of malicious destruction 200 to 1,000. That is also at Randolph Court. Oh boy, okay. You wait for a reading on that one.
Yes.
Defendant having